I've never seen it, so I don't. And
well, you see, whether you're conceding, you're not asserting that it wasn't. I don't see any. Okay.
No.
So, if as the premise of that question suggests, the backing up of the records preserved the record, what?
It was a misquote of the witness, by the way. But what it told the jury was Clerk Peters knew that it would be illegal to bring an expert into the room, and she did it anyway.
And this is a prosecutorial misconduct argument, and that was not objected to when it was said. Is that correct?
The TAR test for
plain error. Very good. And I just remind you have about 2.5 minutes left. I don't know if you want to reserve some time for rebuttal.
Yes, I will.
Okay.
Thank you, Your Honor.
Very good. Thank you, Mr. Case.
This is a big trial, you guys. I came on early to play this. It's live.
Ms. Michaels.
Until after.
Thank you. May it please the court. I'm Lisa Michaels, registration number 38949. Tina Peters was not a federal official. She was a state official who was prosecuted by the state for deceiving state and local officials so she could get an outsider into the state's trusted build process. She had a duty to preserve federal election records, but that's not what was happening here. Here, she hatched a scheme to deceive state and local officials so she could circumvent the state security protocols for the trusted build. She wasn't, that's what she was charged with. She wasn't charged with copying the election server. And we don't agree that her duty to preserve records included a duty to copy the election server, but even if it did,
okay, Carol, this is live
to do that.
Well, in fact, wasn't she instructed, or not she specifically, but didn't the messaging from the Secretary of State's office to all the clerks say, back everything up before we come? Isn't that how they preserve these? I mean, they have a federal duty to preserve records for 22 months. We have elections more often than that would warrant. So isn't the standard practice they do these backups and then they update the machinery for the next election?
Yes, I'm not sure. I want to make sure I answer your question. I agree with what you just said, but
you seem to be hesitating to even concede that making the backup was okay, even though she wasn't charged with it. That seems a little.
Well, she wasn't charged with it, and obviously I'm not the trial prosecutor, but I think we don't agree that there was that duty, that was legal for her to do that. But that's not something that she was charged with. And so for purposes of talking about it, we can say that she copied the records, but that wasn't, and so maybe we could even just assume that that met the federal duty, but I'm sorry, let me back up. So yeah, sorry, I was on the right track. So let's say that did satisfy the, just for sake of argument, that did satisfy, sorry, I feel like this is a little bit sounding off. Does that sound okay to you
I
guys?
think we can hear you pretty well. Can the audience hear her? Okay, I'm getting nods, so.
Okay, good, thank you. And so, but what she didn't need to do, so her plot of deception was designed to get this outsider into the trusted build. She didn't need to deceive the state and local officials in order to copy the election server. So if we just assume that was part of her duty, she could have done that because she did do it outside of the trusted build. She did it before the trusted build occurred, and she did it after the trusted build occurred. So she had copies from what it looked like before and what it looked like after. And no one was around when those copies were made. So she didn't have to deceive. She didn't have to get those security credentials.
But even more to the point, she wasn't charged with any conduct related to copying before or copying after, as I understand the charges. What she was charged with was misleading members of her office and folks in the Secretary of State's office that would lull them into performing the trusted build in her presence with full knowledge that had she been truthful it would not have happened there in her office. Presumably, the machines would have been sent to Denver to do the trusted build. Am I missing the mark at all?
No, I agree with you. That's exactly right. She wasn't charged with making the copies. She was charged for deceiving the state and local officials.
So under the federal statute, section 20701, she had a duty to retain and preserve all records and papers relating
I
to
just texted you, Lucy.
the election. And that presumably would include the official hard drive in Mesa County. Let's assume that the Secretary of State was in cahoots with Dominion. And Ms. Peters knew that the Secretary of
This is
State was
live.
going to monkey with the records, was going to monkey with those records she had a duty to retain and preserve. What was she supposed to do if she couldn't trust the Secretary of State?
Well, she did it. She made copies of the records, what they looked like before the trusted build
All
happened.
records and papers, whether they're copies or not. Would you concede all means all? Every single copy, even if there was a forensic copy, all also included the version of that hard drive that the Secretary of State had access to. And under my, I'll call it a hypothetical, what if she knew that the Secretary of State was going to illegally modify the records and papers that she had a duty to retain and preserve? What was she supposed to do?
Well, so you're saying like if there was a concern that the build would wipe out those records, is that what I think, to me, that she has the copy of what the
More than that the records would be falsified.
Well, I think having a copy of the election server before, again, we don't agree that that was permissible for her to do or that she was obligated to do that by her duty, but she had a copy of what it looked like before.
But all means all,
trusted
doesn't it? It
build.
means every single copy, every copy of that hard drive.
As far as I know, I think we're talking about the copy that was made before the trusted build and the copy after the trusted build. Is that, just so we're on the same page, is that what we're talking about? Or do you
I
think there's another
I think
record?
all records and papers would include the records and papers
Yeah.
that were the official election records in Mesa County that the
This is
Secretary
an
of State was
important
going to
trial
get
here.
access to,
So come on.
right?
Yes, I think we're on the same, I think we agree.
Yeah.
I guess what I'm saying
They
is
should be coming in.
her bringing the person into the trusted
JJ
build,
got in.
that was, her plot of deception was done so that she could bring that person in to observe the builds. Copying the election records before, after, whenever, that's
What
separate.
should she have done if she believed that the records are going to be illegally tampered with by the Secretary of State?
I think she could have made the copies, and not that, again, not conceding that that's legal, but there was another clerk in, I think it's Elbert County, and that's what that person did. He made copies of the election server and retained them. He was not prosecuted because he didn't engage in deception.
And I want to
public
keep going
officials.
back. You keep saying we're not conceding that she was entitled to do it. Judge Tao asked, I thought there was a directive that came out from the Secretary of State that said, before we do the trusted build, back up your records.
Oh, yes, I'm sorry. There are a couple different things at play. So there are the election records that the Secretary of State's office told her office to back up, and that all of the clerks are obligated to do that, and they did do it. And that's what one of our witnesses confirmed, that was done before that's why, and they want to do it because the update does replace the information that's on the server. And so they're required to make a copy of the election records. So there's the forensic copy, and I don't claim to be a technical expert on these issues. So the forensic copy, to the extent that it's different than those election records that the Secretary of State's office directed.
Okay,
her office
let me
to
maybe
do.
try this. The Secretary of State's office told her to copy the record, so the data. But what the forensic copy does is gets both the data and like operating software and everything. It's an entire clone. And you're not conceding one way or the other whether a full clone that included presumably some proprietary software was or wasn't legal, but it doesn't matter because she copied.
You guys want me to continue watching this? I'll have a long show tonight because I got to watch my games tonight. This is important, right? This is Tina Peterson.
Copied that and she's not charged with having done that, regardless of whether or not you're willing to concede that that sort of copy was legal. Is that?
That's exactly
Okay.
right.
Let me, you say that she is not entitled to
Yes.
assert federal supremacy clause immunity at all because of who she
I'm glad
who
I
she
got
is.
just in time.
Or that
That's one of the arguments.
it is one of the arguments, but I want to test that a little bit, because and that's distinct from what she was doing wasn't within the scope of any immunity she might have had. That's a different thing. I mean, if your argument is she could have potentially had some immunity for some conduct, but this isn't within the scope of that. That's one argument. But I want to test the notion that she could never assert it. What if the Colorado had a statute that says election records shall be preserved for 12 months, and after that time must be disposed of, and retaining a copy of those after 12 months is unlawful? And she, as the chief election officer in Mesa County, saw that stat, and that retaining those records is class 1 misdemeanor. She sees that statute, but she decides, I have to retain the election records for 22 months. So I have a federal obligation. I'm going to break the state law. And then when she's charged, why couldn't she say, I am acting pursuant to a federal statute, and therefore I have supremacy clause immunity for taking this conduct? Because I don't think the supremacy clause immunity is limited to federal employees or federal agents. It also, in some cases, seems to extend to people discharging a duty imposed by federal law. So would she not be able to assert the immunity under those circumstances?
So if we're setting aside the argument that you have to be a federal official, employee, or officer, if we're just talking about whether the duty would, I mean, really then the question is, was her conduct necessary to fulfill that duty? So.
And that would be a jury question, wouldn't it?
No, I mean, if we're talking about, I think you're getting at the affirmative defense, but please correct me if I'm wrong. It's not a jury question because, well, I guess, are we talking about the hypothetical, or are we talking about what actually happened? If we're talking about the facts of the case, it's not a jury question because that duty did not, the question actually for the affirmative defense is even more narrow than the supremacy clause issue, because the language of the affirmative defense, the duty or law has to require or authorize the criminal conduct. So she had to have some evidence that a duty required or authorized her to deceive state and local officials. Excuse me for just one moment.
Not entirely, right? Let's move away from the attempt to influence public servant and go to the official misconduct. And let me say, for the sake of discussion, the battle over the evidence of her intent conflates the concept of intent with motive. I'm going to state that as a premise. But even her motive, it may not be relevant to the official misconduct or the attempt to influence a public servant charge, because what she had to intend to do for that crime was deceive someone and affect that public official's decision. But the official misconduct charge was charged as with the intent to receive a benefit for herself. Why is it not relevant to the jury for her to say, I didn't intend to receive a benefit for myself. I intended to do what I thought was my job and protect the election process? Why was that evidence not relevant, at least to that charge?
Well, I think, and I could be wrong, my understanding was that the theory that was, and I don't know, again, I don't have the indictment right in front of me, but my understanding was that and I think actually there's the interrogatories reflect what the basis of that charge was and what the jury verdict was. And I think it wasn't based on the benefit to herself, but it was based on the violating the election, the state Secretary of State's rules. And so I think it's a little bit different. But I think it's the same idea. And those rules, by the way, just to put it out there, are about access and access to that secure room and keep maintaining logs of who's coming and going. So it's the security protocols, essentially. So, okay, sorry. And so I don't think I mean, I think it's still the same. Even if she had this motive, I think it's still, her intent is still to violate the security protocol. I mean, there are different things charged here. We have the attempt to influence the conspiracy to commit criminal impersonation and violating these security protocol rules. But it's really all the same. It's part of this scheme of deception. That is what she was charged. That all of it relates to that. And so her intent there, even if she had a motive, she has a motive to conceal this outsider's identity, or she has a motive to preserve whatever that she thinks she's preserving election records. That is, she still has that doesn't take away, it doesn't negate the intent that she had. She still, because she had that motive, she had the intent to deceive to engage in this plot of deception.
But engaging in the plot of deception has no bearing on the charge of first-degree official misconduct. And I'll have to explore the indictment a little more closely. But I am presently under the impression that the charge was based on the elements of that being an intent to obtain a benefit for herself
Or someone else.
or someone else. So if her argument, even if it wouldn't fly with the jury, if her argument was, my intent wasn't to benefit myself, my intent was to protect the election process, while that would have no bearing on whether the felony charges that require only an intent to deceive, the first-degree official misconduct elements don't have anything to do with an intent to deceive. They have to do with an intent to gain a benefit. Why was that evidence not appropriately submitted to a jury?
I'm sorry. For the microphone, I'm sorry. If I can just have a moment to look at the jury instruction on that, because I don't have. I guess my first response, without pulling this out, just to verify, is that the intent doesn't necessarily go to that benefit. It would go to the conduct. Did she intend to engage in that conduct? And so there's the intent, of course, applies to the different elements. And so it would apply to, it wouldn't negate her intent to engage in the conduct that constituted a violation of, or is this the?
So here's the charge for you.
Official misconduct.
Honor about the dates in question. Tina Peters, a public servant, with intent to obtain a benefit for any person. So it does directly apply.
Oh, no, but sorry, could you, so there's other, I guess what I'm getting at is what the actus reus is. And so that's the part where her intent to engage in the conduct itself.
But again, if there's a specific intent crime, which this is, the prosecution has to prove that specific intent. The intent to obtain a benefit for any person or maliciously cause harm to another. And she says, even if I did what I did, my intent wasn't that. And here's the evidence of that. The jury has to hear that evidence to be able to determine whether the prosecution proved the charge.
Well, the jury did hear that evidence. There was ample evidence admitted, and I cited it in the brief. I have the citations here too, if that's helpful, but that evidence did come in. I mean, the court limited it because the court was ensuring that it didn't turn into a mini trial about.
So is that a 403 ruling instead of 401 ruling? I mean, is it a
relevance?
Relevance as opposed to, or is it undue prejudice?
So what do you guys think what's going to happen after this hearing? What do you think is going to happen?
Yes.
As opposed to 403 being undue prejudice.
And
Yes, thank
does
you.
a trial
I'm
court-
sorry.
Sorry, does a trial court with, you were about to make an analogy of the sideshow
Right,
overcoming the circus.
Daniel, Intel will be after this.
When it
one.
comes to a defendant's constitutional right to present a complete defense, does a trial court have the ability to curtail that in the interests of not letting the sideshow overcome the circus? Don't they have a constitutional right to present a complete defense? And the only restriction on that I think is out there is that means the court can prevent cumulative or irrelevant evidence, but it cannot curtail the presentation of relevant evidence.
Well, I think, I'm not sure if you disagree. Our argument is that the danger of unfair prejudice, confusion of the issues, or misleading the jury substantially outweighs any probative value. So that's the basis.
Is that the basis of the court's ruling?
That is the basis of the court's ruling, yes.
Happy Wednesday.
And if we're talking about so there's no error because of that. That is the basis of the ruling. But even if there was some sort of finding that the court should have let that in, it's not a constitutional violation because she was permitted to bring some of that evidence in, and she vigorously cross-examined the evidence. It's only if she's prevented from
A complete
presenting
depreivation of
any
presenting the
exactly.
defense.
Yes,
That rises to constitutional.
Is that the
issue.
Cutzinger language?
correct. Yes.
What do you do about the fact that I can't remember that it was actually a later proceeding in Cutzinger itself at the habeas level. Judge Kane at the federal court strongly challenged the validity of that statement, that goes way too far, that it doesn't have to be a complete deprivation, because that essentially shifts the burden to the defendant to defend their constitutional rights instead of to the people to protect them.
I'm not familiar with the continuation of that case into habeas, but I will say that wouldn't be binding on this court. We have to rely on Cutzinger because that's the case law that applies for us since we're in state court.
Can
Okay.
you come back to my hypothetical very briefly?
Yes.
Could she have asserted under the circumstances of my hypothetical a supremacy clause immunity defense?
Oh, right. And if you could remind me exactly. So you're saying, let me just offer if I understand. It sounds like you're saying that, I don't remember the details, but it sounds like you're saying if the state law directly conflicts
Right.
with,
Yeah.
I think if that's, again, setting aside the argument that she has to be a federal official, I think that it seems to me, I mean, again, you have to engage in the analysis of whether it was necessary. So then you're looking at, is this the only way to achieve that duty? And so, again, without remembering the specific details, and that would take us,
Okay.
pretty far afield. I think,
And maybe what but you still seem to be maintaining that she can't assert supremacy clause immunity at all. Full stop. She is not, by virtue of her position, she's just not entitled to do it. That's your first line position, right?
yes, yes, our argument is that she has to be a federal official
Okay.
in order to assert that. But if you don't agree with that, and given the facts of this case, that she didn't need to engage in that criminal conduct, the deception, in order to.
But we only get to that question if she's able to assert it, though, right?
Yes, exactly.
Is
You
it
could
fair to
just-
say that while there may be a supremacy clause issue between the conflicting statutes, she would have an affirmative defense of the public duty, but not an immunity?
Sorry, can you say that one more time?
In his hypothetical, she might still have an affirmative defense that I was executing my public duty,
Oh,
but that doesn't
Yes.
mean she's immune.
yes, I think that would fit better in that. I mean, really if we're talking about the affirmative defense, really what that defense is available for is the situation where you have some sort of where the law says this is a crime, but then you have some other duty that requires you to do it. Like we have the case where the process server can assert that defense for the crime of trespassing. So that yes, I think the hypothetical would fit into that.
So it would be the state law affirmative defense, not the supremacy clause immunity, because you contend that it's not available to her as a state official. Fair enough?
Yeah, for your hypothetical.
If it's
for the
okay
facts
with
of
my
the case.
colleagues, can we turn to sentencing?
Actually, I was hoping to address the substantive charge
Okay,
of
go ahead.
conspiracy to commit criminal impersonation.
Okay.
That charge was identified in the indictment as a class 1 felony or a class 6 felony under the statute subparagraph 1A. But the language of the charge actually parroted 1B, which was a class 1 misdemeanor.
Correct.
And your argument is, to the extent that was error, that convicting her of a class 6 felony was error, it was harmless error because the evidence was sufficient.
Plain error, but yes.
So I want to state a hypothetical. A person is charged with second-degree murder, which is a class 2 felony under 18-3103, that they knowingly caused the death.
I'm sorry, can you just start over? I wanted to correct I got caught up because I wanted to just clarify, since harmless and plain error kind of opposite. Our argument
You're saying
is
it's
that
not reversible. That's the key.
Correct, but under the plain error standard, not the harmless error.
That's the key. So my point is, you're saying it's not reversible even if it's error.
Correct.
And I want to say, as a hypothetical, somebody is charged with knowingly causing the death of another under 18-3103, a class 2 felony, second-degree murder. It is charged in the complaint and information, or the indictment if it was a grand jury, as homicide, citing the first-degree murder statute and calling it an F1, even though the language was of the class 2 felony. You go to trial, and there's evidence of after intent and with intent and after deliberation, which is what makes it a first-degree murder. But they were charged with the jury was instructed on, and the jury found guilty on the language of a Class 2 felony. Is it your position that a person can still be convicted of a crime with which they were never charged and with which the jury was never instructed, as long as the evidence is sufficient?
Yes, I think that is what the case law indicates, that if it's just, in this case, I'll just point out too that, I don't have the language of the statutes that you're citing in your hypothetical, but it was one word, might, and it was already.
Yeah, but that one word distinguishes it from a felony to a misdemeanor.
And this case made an extra sentence, 15 more months in the Department of Corrections that couldn't have been given had it been a misdemeanor conviction. It clearly affects a substantial right.
And I'll just say, I'm confused as to why the people are continuing to maintain that the proper remedy on this isn't to enter the conviction for the misdemeanor, because the indictment used the word might, and the jury was instructed on that, so that's what the verdict is. I am baffled as to the position that's being taken that we can somehow overlook that and still enter the felony because the evidence that was presented at trial would have supported the felony. Are you still maintaining that position in front of us here today?
Yes, that is our position.
What case law supports that argument?
I'm sorry.
What case law supports that
I've cited
argument?
it in my brief. I don't have it right in front of me, but the case.
It's the omitted elements
Yes,
case law,
correct.
right?
Mhm.
But that's just where the element was omitted, and but the element that was omitted wasn't in dispute. Here, the jury was affirmatively misinstructed. It was instructed on the misdemeanor, and it found her guilty of that misdemeanor beyond a reasonable doubt. This isn't the omission of an element. This is a misinstructed jury. How can we correct that by saying, no, we'll just assume that because she could have also been convicted of the felony, we enter that even though we don't have a jury verdict? That's a...
I understand it's a difficult position
Okay.
for the people to be in. But
It's not a position you have to take.
I came out early.
Thank you. But I do believe that the omitted element language
is why.
applies because to me, I understand, I can hear from the way you're talking about it, it seems more egregious to add this extra word than it is to omit an element. But to me, omitting an element is a pretty big deal. And the fact that can be
Except
not
in those
reversible.
cases, at least the person was originally charged with the elemental language. Here, never on the table.
That is true, but if I can just add, and again, it seems that I will not be able to convince you, but I just want to put my argument out there, which is that there wasn't a confusion from the parties about what they were talking about because the correct statutory citation was used. So they were on notice of the statutory citation. The language was incorrect, but the statutory citation was correct.
Couldn't that also mean that the prosecution was on notice that they'd only charged, since the language was correct, they'd only charged that language and not, both of them were on notice of something wrong.
Oh, yes. I guess what I'm saying, Your Honor, is just that there wasn't a notice problem because there was the statutory citation. And the parties treated it as though, I think it was an oversight. I think everybody believed that if they had charged and used the language that's what the record bears out, in my estimation. But I understand I'm not going to convince you. I just wanted to put that is the argument.
I'd like to turn to the sentencing issue. We'd like to hear argument on the sentencing issue. So the trial court in sentencing referred to Ms. Peters peddling snake oil that's been proven to be junk. She tried to undermine the election and she was weaving tales. Didn't he consider uncharged conduct as he referred, given the references to snake oil, et cetera? Wasn't he considering uncharged conduct in sentencing her? And wasn't that an error?
Well, are we talking about the First Amendment issue? I'm not sure that is, one, it hasn't been raised, but I understand that if it's a concern to the court. I don't think that that's something that's problematic. I mean, all of that was part and parcel of, it was the context of the criminal conduct. She wanted to promote these allegations of election fraud and her scheme of deception, everything she did.
But she wasn't convicted of publicly saying it was election fraud.
Correct. But I think because it's the context, it's relevant. I think it's something that the court can
Why
consider.
is the context relevant when the court excluded much of the evidence of election fraud? So on one hand, the judge says, Ms. Peters, you can't bring this in. On the other hand, he refers to it when he's sentencing her.
Well, and again, I know the court is aware of this, but if I just want to make sure the record is clear that he didn't exclude it entirely. He limited it. But
Right.
also she spent a great deal of time at the sentencing hearing talking about this election fraud. She used it as a platform to make all of these allegations. So of course it was relevant to what the court was doing at the sentencing hearing. The court was entitled to consider what she said.
Well, then let's turn this as a First Amendment issue. Is that the court's entitled to consider the larger context, but there's some limitations to that, right? The court cannot punish her for the exercise of her First Amendment rights. Isn't that a fair statement as a broad principle?
I think that's correct. I mean, if the court can consider the conduct and it may factor into the sentencing, just to break that down a little bit. I mean, I think the broad proposition is correct that we can't punish people except in these circumstances, which we're not talking about right now. But I think to the extent that it is relevant then the court can consider it and factor it into its sentencing decision.
But that's the question is does her political or personal views, is it relevant? Or is it something that is inappropriately considered? And I guess I would also frame it as, in defending the convictions and what testimony was brought in at trial and what defenses she could assert, the people very narrowly tailor this to, we're not talking about her election conspiracy stuff. We're not talking about making the copy before or making the copy after. We're talking about this very specific conduct of misleading the Secretary of State and the like. But then at sentencing, the sentencing language and the considerations end up broadening out from that considerably and getting into the very issues that you say is outside of that box that helps you defend the convictions on their merits. But my concern is that it did substantially inform the sentence that was imposed, and that creates some constitutional problems, and you don't get to ride both horses.
Well, I think it's a different forum, and that really is, I mean, the rules
It
that
is.
we have for the jury are different because
Absolutely.
and so I think that is the first part of my response. The other piece of it is, again, she made it relevant by spending, she had a slideshow. She spent pages and pages going on about this. How is the court supposed to just ignore that? I mean, of course it's going to be, the court is considering, it has all its considerations in front of it. And it referenced, it said she doesn't have any remorse. In fact, she's standing up here and doubling down on it. So I think the court, and I see that I'm out of time, so I'll finish there unless you wanted to.
No, I think this is important territory. But it's one thing to say, look, she said this and I don't agree, but then to impose additional, or to make it part of the calculation as to whether or not you're going to impose the length of the prison sentence, to me, just because she raised it means that the court can comment on it as to whether or not perhaps it's persuaded or the like. But my concern is that the court didn't say that she's engaging in all of these hoaxes and she's undermining public confidence and she's doing all of these things that I think are very detrimental to society, but I'm not considering those for purposes of sentence because she is here on these convictions and that is the exercise of her First Amendment rights. Instead, I'm going to impose the sentence based on this. So we can address it and reject it. But what my read of the transcript is, the judge considered that and it went into the calculation of the sentence, and that's a First Amendment problem. Can you disabuse me of that concern?
Well, I think the court used strong language and addressed that. I think the court, I mean, again, as I've said, it's the context, but I think if you look closely at the transcript, the court did lay all that out and then say, but at the end of the day, I think that might even be the quote. At the end of the day, this is about what you did. You violated these security protocols. You had a duty to enforce the security of the elections, and instead you violated it. So he ended up, that was the basis of the
But counsel, this was not about a security breach. This was about misleading public officials to conducting a trusted build in the presence of other people. She wasn't charged or convicted with a security breach. And so that's still beyond the charged conduct and the convicted conduct. I mean, did she try to make it relevant? Yes, but the court exercised its discretion, and you say correctly, to keep that out, but then it let it inform that broader picture, inform the sentence that it imposed. I think having it both ways it fundamentally undermines or calls into question the fairness of the sentence potentially. Why doesn't it?
I understand the concern. I do, and maybe I misspoke. I mean, I urge the court to look at the transcript because I do think the court made that distinction and talked about what she did here, deceiving. I mean, whether we call it violating the security protocols or saying she's a public servant, she's supposed to enforce this, and then here she is deceiving other public officials.
Actually, but that's my concern, is we can't just say, whether we want to call it this or that, it's still the same thing. That's not true. What was very, very important here is that what she did was brought people in, and what she was charged with was lying about who they were so something would occur in front of them. She was not convicted for bringing those people in. And so I think
Right.
that the constrained nature of what these offenses are also should inform what the sentence is that the court imposes and what conduct it considers in deciding what the appropriate sentence is.
And I apologize, maybe I'm not being clear. I am trying to focus in. I think the court was focused on the deception of these public officials, and that is what she was charged with.
But what does it matter, given the passage of time, the departure from the office, and the fact that she is still espousing them? He focused, at least for what I see as a significant part of his comments, on her continued statements. Why isn't that a problem? She's not in a position to do what she did again. There's not a specific deterrence aspect of the Stewart case cited by the people on the attorney who said they would do it again. She can't do it again. I mean, unless the people reelect her, which then question whether they want that. But this is a democratic society. So she's not in a position to do it again. Her continued belief in that, in the facts that she asserts, or the situation she asserts, has no bearing on any sentence consideration. Not deterrence, certainly shouldn't be punishment. Why should we not be concerned that he focused so much on her continued peddling of the snake oil?
I mean, I'm not saying you shouldn't be concerned, but I don't think there's an error. I think that she spent so much time talking about it. It was the backdrop of the case. There's a lot of publicity. Maybe the court felt like it had an obligation to say that it did not agree with what she was saying and that he thought the conduct was improper. But if you look at
he can't sentence her more because he doesn't agree with what she's saying.
I agree with that. I'm saying, I think there's two things that happened. I think the court made some comments, and then I think the court, if you look at the transcript, talks about the basis of the sentence, which is her conduct, her criminal conduct.
And I don't blame the court for how it characterized it, given what occurred at sentencing up to that point. I mean, the sentencing argument on both sides hadn't been well tailored to the convictions or what she was tried for and convicted for. But at the end of the day, isn't the judge's responsibility to make sure to kind of separate that wheat from the chaff and only focus on appropriate considerations? Or if it wants to address those, explicitly tell us that it's not considering those in the imposition of sentence.
Maybe that would have been a better practice. And maybe, we can disagree with how the court, whether the court was appropriate for a court to make those kind of comments. But I think that's a different question than whether he sentenced her based on that. And again, I think the transcript, it's very easy to focus on the very strong language that the court used. But if you look, it really did turn the page essentially and say, this is what we're here for, and this is why I'm sentencing.
And we should consider the totality of the sentencing transcript in making our evaluation, is what you're telling us, right?
Yeah.
Okay.
Exactly.
Anything else from my colleagues? All right, very good.
Okay.
If you would give 9 minutes of rebuttal to, I'm adding the additional 7 minutes that we allowed them to go over, so that it's a total of 9. And with that, Mr. Case, the floor is. Well, give me just 1 second, Mr. Case. Let's get can we get a total of about 9 minutes on the clock? Perfect. Yeah, there. Just start it.
Kind of like
Awesome.
football, reset the clock. So I like the way the court zeroed in on sentencing because you have a 70-year-old woman, nonviolent, first offense, probation eligible, never had a traffic ticket before all this, given 9 years in the penitentiary. So under DOC regulations, she ought to be in a minimum security facility with similar defendants, nonviolent.
How do you
first
respond to the
offense.
people's argument that despite the harsh language, when you continue to read the transcript of the sentencing hearing, the court actually sentenced her based on the counts on which she was convicted?
Well, I say that's baloney. I was there. I heard the way he imposed the sentence. He was vicious. And we're asking the court, if this case is remanded, please order a different judge.
Did you raise that in your brief anywhere?
Where?
The request, I mean, that's a
Yeah,
different,
that's the relief we asked for,
Okay.
based on the fact that
Is
he
it-
denied her a free trial and sentenced her to 9 years because of what
so
she
if we,
was
so you're saying if we reverse and remand on the sentence, that it be resentenced in front of a different judicial
Well,
officer?
and retry.
But if it's just reversed on sentencing, it's resentencing in front of a different judicial officer is your request?
Yes, please. Your
Okay.
Honor. Okay. So I didn't know this, but until this case, but Colorado doesn't have minimum security facilities for women, just men. They have 4 minimum securities for men, none for women. So who are Clerk Peters' cohabitants in La Vista? Murderers, child molesters, drug dealers. That's the majority of the population. And why is she there? Because of what she said.
Counsel, can you address the response that to the extent the court commented on things that she had said, it was based on the statements that she injected into the sentencing proceeding. She injected how she, the reasons that she was served.
How's everybody
She
doing?
talked in
Everything
her,
okay?
we're looking at, I've read the whole
This
sentencing
very
transcript.
good, right?
And she put some things in there that were also outside of the scope of what was immediately before the court. Why didn't
We're gonna have a
that
long show
open the
tonight.
door to the court addressing the issues that she raised and the affirmative representations that she made about what her motives were and her honesty and integrity?
Well, I think Judge Tao answered that question.
Interestingly enough, I wasn't listening closely enough because I'm listening for answers to come from the podium, not next to me.
You
So
said it's-
We've been
it's-
colleagues for 15 years. It wouldn't be the first time.
Said it's up to the court to, give her a fair trial and a fair sentence and to rule justly, not bring that in when it's outside it wasn't what she was convicted of.
Fair enough.
Are you saying that the court couldn't address her slideshow presentation, her PowerPoint presentation? that
Sure, he could comment on it, but since she wasn't convicted of anything in it, he can't sentence her for it. The one thing that Clerk Peters did bring up at sentencing that he did consider and used as a sentencing aggravator was her prior conviction for contempt. That conviction was erased, was overturned, vacated after sentencing. So she's entitled to be resentenced for that reason alone.
And that's not an error on the court's part, because at the time that was a conviction that had validly entered. It was subsequently vacated, right?
Well, we submitted evidence at sentencing that the whole thing was a fabrication by the DA, but the judge overlooked that too.
Okay.
So I want to go back to your earlier questions on the immunity issue. So there's nothing wrong with using a false name. Anybody, you're not required to give the name that's on your birth certificate or your driver's license, unless you're doing it for fraudulent purpose. So here, there was no fraudulent purpose. The clerk introduces Conan Hayes as Jerry Wood. Now, what's the harm to the Secretary of State? None. After the Secretary of State leaves,
The harm is to Mr. Wood. It doesn't have to be harm to when there's a criminal impersonation, somebody gives a false name to avoid an active arrest warrant. The police aren't harmed. It's the person whose name was used if they're a real person.
well, Gerald Wood was not harmed. He volunteered to let Hayes use his key card. And the key card is issued so the clerk can control who's on her premises.
Well, I think that was disputed at trial, right?
Yes.
Yeah.
So 8 times during this trial, the prosecutor referred to Hayes as a cyber mercenary. Clerk Peters wanted to present evidence and tried to that Hayes had worked as a confidential government informant, that his ID had been protected in the past, that he had used alternative identities, that he was given authorization to access voting equipment for purposes of writing reports for the government, and the court wouldn't let the jury hear it.
But
In
I don't
fact,
understand how that's a defense to anything that she was charged with respect to attempt to influence a public official or the criminal impersonation.
because there has to be an intent to deceive, and the deception has to be towards
No, there
somebody.
does.
No, there
There has to
doesn't.
be an intent to alter a decision.
Right, alter a decision.
Right.
what's the
So her
decision?
intent, the decision is to conduct the trusted build
Yes.
in the presence of people that she knew the Secretary of State would not conduct the trusted build in front of.
Yes, but
That-
what's the harm?
It doesn't need to be harmed. That's an official decision that she is attempting to influence.
Well,
In fact, if
it
anything,
is-
the argument admits that she intended to deceive. She thinks she has a valid reason to do so. Again, I
Right.
mentioned it in questioning your opponent. You're conflating the issues of motive with intent. Elementally, for that crime, the only intent required to be proven is the intent to impact the decision of the public decision maker or of the public official. She intended to impact it. She's saying, I needed to hide his identity. She's admitting essentially doing it.
Yes.
She just says she has a good reason. That's motive, not intent.
Well, okay. Appreciate the distinction, but there's no harm to the Secretary of State. When the trusted bill, when the wipe is done, they do an acceptance check. Secretary of State checks it, they leave, then Dominion checks it, then.
Can you
then they-
point to me in the statute where harm is an element of this offense?
No, it's not an element of the offense.
Which is why the court ruled it was irrelevant, right?
Well, but the point is, the jury could consider harm in deciding what her intent was and what
Why?
her motives were. Why?
The jury didn't have to decide what the motives were. The motives are irrelevant.
Well,
They're not elements of the offense. They're not something for the jury to consider, are they?
yes, because she thought she had a duty to protect those records and to see what was happening to her county computers during the trusted bill. That was her job. And so it was important to her that Hayes had been authorized to use false names in the past and that he had the credentials to do his job. So we submit that's why that evidence should have been allowed. The court said during the Curtis advisement, I'm not going to let her say that. I'm not going to let her testify that she knew Hayes was an informant. That's why she didn't testify and get to present her defense. Now, on the issue of sufficiency of the evidence, there were 3 counts where there is a fatal flaw when and if this gets remanded. The first is the attempt to influence Romero. It's all based on Exhibit 18, this email. There's no evidence Peters knew about the email. It was sent by Sandy Brown to Romero. She wasn't copied on it.
Wasn't that a fact question for the jury?
Well, yeah, but it's not if there's no evidence to support it.
All right,
There's
counsel,
simply no evidence she knew about the email.
very good. Your rebuttal time has expired.
Thank you, Your Honor.
Very good. Thank you, counsel, as well as members of the public. We appreciate your interest in this case and your patience this afternoon as you waited for it to be called. I think we may have started a little bit late, but I appreciate that. And I also appreciate having folks here that get to see our democracy in action and what we do in these courts. This is not, isn't Law and Order. We're not doing the most exciting work here, but it's very important work to our democracy, and I appreciate the concern and attention that you paid to it. Thank you to counsel on both that had an opportunity to argue and who were also on the briefs. Your briefs were very helpful, as was today's argument. The case will stand submitted, and a written opinion will issue in due course. And with that, we will be in recess if the bailiff will so announce.
Okay, everybody, what do you guys think? What do you think about all that garbage? Okay, we'll start off with short clips. I got two short ones from this lady.
To your attention since we're in 2026. Now, in the back of my Geneva Bible, from the year 1560, this is what it says. From Adam unto Christ are 3,974 years, 6 months and 10 days. And unto the birth of Christ, unto this present year, is 1560. Then the whole sum and number of years from the beginning of the world unto this present year of our Lord God, 1560, are just 5,534 years, 6 months, and the said odd 10 days. So I subtracted 2026 minus 1560 when this was written, and it equals 466 years. Anyone who reads the Bible knows that the world was created in 7 days. 2 Peter chapter 3, verse 8 says, "But beloved, be not ignorant of this one thing, that with the Lord 1 day is as 1,000 years, and 1,000 years as 1 day." So to know what year we're in, we would just have to add 466 to that number that he gave us. And when you do, you get 6,000. Now, the author also said that it was 5,534 years and 6 months and 10 days at that time. I mean, just take a look around. Anyone with the Holy Spirit can feel the times we're in. Revelation chapter 17, verse 12, "And the 10 horns which thou sawest are 10 kings, which have received no kingdom as yet, but receive power as kings 1 hour with the beast." We know from Nebuchadnezzar's dream that the statue had 10 toes, and that would be the last empire, just like Revelation said. And this would be the revived Roman Empire. Now, if we look at the Club of Rome's map, there is literally 10 kingdoms. The kings just haven't gotten their kingdoms yet. But we know one kingdom, America, that seems to be getting it shortly. The Lord said that there would be birth pains and that they would increase over time. During the final moments of birth, during the labor, the intense burning or stinging sensation felt as the baby's head crowns is called the ring of fire. And we know that there is a specific place on our earth that is called the ring of fire. And this ring of fire has been lighting up for months now, and it's increasing. Anyone with a shred of discernment knows that the beast system is being made right now. We just had another state launch digital ID in the United States. And not just in a Christian view of this, Baba Vanga predicted alien spaceship would enter Earth's atmosphere in outbreak of World War III for 2026. We have huge protests in Iran right now. And it seems like they will have a regime change soon. And it will most likely be this guy. He became the most prominent Iranian to have ever visited Israel. And he believes in a thing called the Cyrus Accords. It is a proposed future Middle East peace framework named after Cyrus the Great, who freed the Jews, envisioned to follow the Abraham Accords Trump brokered, aiming to normalize Israel-Iran relations. Now, at the time, this is just a vision and not an implemented agreement. Don't find it a coincidence that they always call him Cyrus, or that they made a coin with him and Cyrus on it. And if that man is placed in office in Iran, I would not be surprised if the third temple doesn't get to be able to be built, because he's a friend to Israel, and that's what Israel wants. Y'all, this is all pointing to prophecy. Whether you want to believe the Bible or not, it is happening. What was written in a book thousands of years ago is coming true. Y'all might want to reconsider that relationship with Jesus. And if you do, the Bible says that if you confess with your mouth that Jesus is Lord and believe that he died, was buried, and rose again for the remission of your sins, you will be saved. Don't wait until it's too late. Listen up. I've made many.
Okay, that's another good one with her. I'll just do one. I got a two-parter here from Minnesota. About 5 minutes each for.
And apparently, Greg Abbott
Oh.
says Texas is not putting up with the defiant protesters, the protesters in Minnesota. He also says Texas is not Minnesota, but why does he say this? Well, they apparently tried. Now, for the last 2 days after the shooting that took place of Renee Good, when she tried to run over an ICE agent, apparently protesters saw a way to start rioting in Minnesota. Just yesterday, a CNN personality anchor was walking around in the streets, literally filming as they tried to break into a hotel that had ICE agents in it. Well, that literally, they tried to do that here, and it just didn't end up well for this protester. Ladies and gentlemen, I don't want to show you too much into depth because YouTube doesn't like these types of videos where they'll demonetize a video of like an arrest happening or some type of riots, but they are rioting. That's what they're doing. None of these are peaceful. And again, let's take a look here at what they tried to do. So apparently they tried to start fighting police officers here in Austin, Texas, and they're not having it. They are not having this. Here we go. Look at that. Look at that. So you got the protesters right here. By the way, bunch of white liberals. Again, the most dangerous demographic, white liberal women. Somebody said that. I'm quoting somebody there. But here we go. So they tried to basically they thought that they could start taking over streets. So in Minnesota, they've taken over streets. If you look around Minneapolis, Minnesota, cops had to literally run, right? They were running for their lives. And now here they tried to do the same thing. And boy, oh boy, it just didn't work out for them at all.
Hey, Samantha, happy Wednesday. This started in now. We were listening to
Well, you guys already know what happened next. So we have 2 arrests happening right there. This is posted on Fox. Fox was actually posting this like, hey, here we go. And here's Greg Abbott, by the way. Greg Abbott says Texas is not Minnesota, letting them know very clear, right? So breaking news, Austin police have charged into the crowd. I'm seeing at least 3 people arrested. So they started charging into the crowds. They said, we're not going to get overrun. And a lot of people on the left are like, well, why are you charging people? They're innocent. They're just peacefully protesting. Well, you must not have seen what they did yesterday to the Minnesota police chief. Well, let's actually take a look at what they did to the police chief. This was just yesterday, right? Breaking Minneapolis police, including Chief Brian O'Hara, who defended the anti-ICE rioters, just got chased down and attacked by the people he was supporting. You can't make this up. And here's some of the video. So as you can see, there's Chief O'Hara right there. There he is. And literally, they are telling them to go. They're taking over the streets. So this is the difference between, again, Minnesota and Texas, right? So they're running. Look, one cop car is out of there, right? You got all these protesters literally moving in and overpowering the police force there, right? Look at them. Look at this. They're trying them. They're moving them. They're literally touching them and moving them. They're running in panic. The reason why I'm not playing the audio here is because there was a lot of curse words. Look, this cop just got pushed. This cop got pushed. And then the other cop is basically like, look, we have no time. We have to run. We have to run for our lives here. We got to get in our police cars, let them take over the streets, and we got to move on. Look at that. They're getting chased down by protesters, bro. This is crazy. So let's go back to Texas. Texas ain't playing that game. Take a look. So again, I don't want to play too much audio and I don't want to show too much because of YouTube's algorithm. But as you can see right here, they're pushing in and running into the crowd, making various arrests. There's one. Well, welcome to the great state of Texas.
Hey, part one, this guy's good.
Rioters now breaking into businesses in downtown Minneapolis. Windows broken and rioters have entered. Tim Walz is MIA. Meanwhile, police chief, and again, who defended all of this. And there you go. After they broke in, this is what they're doing in these businesses. And I don't want to show the actual videos because of the fact that we can get, flagged for this video, but you guys get some of the highlights there. So they're breaking into these businesses. They're breaking it as a whole. Let me actually show you, right? Insurrectionists are currently trying to invade the hotel in Minnesota that they believe agents are staying in, right? Where are the effing police? They have allegedly breached a door. We have not seen any cops. And again, it's CNN doing what CNN does best. They're speaking about that. These protests aren't really that bad. We're just showing, people are mad. People are very emotional as to what happened to that girl. And guess what?
So, Laura, right now we are in downtown Minneapolis. We've been following this protest outside of a hotel where these protesters believe federal agents may be staying. And just in the last few seconds, it appears they're trying to get actually inside this hotel. You can see this ramp that they were all around me a few seconds ago, and now they're up this ramp. I can see a door open to this particular hotel, and you can see and hear how much noise they're actually making right now. Earlier, they were shining lights on some of the windows, truly making as much noise as humanly possible to this point, banging on drums, blowing their whistles, out with their signs as well. This is at least the second hotel they have been to in the downtown Minneapolis area, appearing to be under the belief that agents are staying at the hotels.
So CNN is literally filming the break-in, right? Because usually what a lot of the mainstream media tries to do with these protests, they try to literally show down. They try to literally nothing much is happening here. Everything is okay. Nothing's really happening. But what they're filming is people trying to break into a hotel they believe the agents are at. What happens when they get in? Are they also going to film that? Is this not worrying to the country? We should not be worried about this.
At which they arrived. Now, again, you can hear the drums, but I can't emphasize enough. It was just a few seconds ago as we're going to get closer to this ramp to see what we can see. Excuse me here. Where you can see the door open. It doesn't seem that they've made much more progress beyond that door opening and a good portion than actually going in. Now, while there was law enforcement in this area a little bit earlier in the evening, we have not seen any in the last 30 minutes or so to this point, as they are now clearly, it seems to have breached at least one of the doors here, but at the very least, everyone out in the street making as much noise truly as humanly possible. And when you look at the size, it actually isn't the overall biggest that we've seen, but you actually see here they climbed a ladder of this other little vestibule here on the side, and they're up there observing as well. As you've got apartments.
They are literally filming protesters trying to break in to literally unalive the agents. I mean, this is crazy. Again, this is some wild stuff happening in Minneapolis right now. And again, going back to the police chief that was attacked. Never forget when Minneapolis Police Chief Brian O'Hara told Somalians to call 911 if ICE showed up to arrest them. Basically, again, taking the side of it's wild to see this. It's wild to see this. It's wild to see, but it's not surprising, but it is pretty wild to see them literally get ran down by protesters. They're ran down by protesters. Meanwhile, this is who they said that they represent. They represent those people that are mad. Take a listen.
Folks that are masked, that they're not sure if they're law enforcement, that they may be kidnapping people. We have had those reports. I want to be clear to the community. The community should know that if you see something like that is legitimate, that you don't know if someone is law enforcement, you should call 911. And you should provide as much information as possible, because let's not forget, we very recently had tragedy in this state by someone who was purporting to be law enforcement. So please, let's be clear. That's something everyone should report, and that we will immediately respond to, and we will document whether it's.
So again, this is who he is. And I don't want to show too much, but.
Okay, that was a new guy. That was pretty good. There was a shooting when I came on this afternoon. We'll play a couple minutes. Found out where it's at. Florida.
During an incident, let's listen to the very latest.
As you can imagine, it was a chaotic scene in the middle of morning rush hour traffic, which brings into light some great concerns that we had upon arriving here, because we had our motoring public, our businesses that are trying to make a living, all having to deal with this as it's unfolding, again, in a very violent manner. Immediately thereafter, once we were able to secure our 2 police officers that were wounded in the exchange and get them treated and taken to the hospital, we of course began a search of the area. Information that we had received took us to a nearby business, a lumber yard, where the initial suspect was seen entering. We sadly discovered a subject inside of the business that was also deceased, suffered a gunshot wound as well. So we now believe confidently that it is the same suspect that entered the business after having parked not far from here at 1300.
All right, so I was out of Florida. I'm going to do the X2 part from yesterday. We'll get the 20 minutes out of the way, and then we'll do the short ones toward, the middle. But X2 report, I got 2, so I've got quite a bit to share. Oh, this one's a little bit long. 28. Well, long, so don't worry. Worry, how you doing?
Hi, and welcome. You're listening to the X22 Report. My name is Dave. This episode 3817 AN. Today's date is January 13th, 2026, and the title of the episode is Central Bank Awakening Has Begun. Sometimes you need to show the people TikTok. Hey, listen, if you're over 40 and planning to retire someday, the window to protect what you've built may be smaller than you realize. Here's a question most people never ask. Is your portfolio built for what's coming next? Many investors in their 40s and 50s discover they have little to no exposure to precious metals. That means their savings are largely tied to markets, policies, and paper assets, with very little protection if conditions change. As retirement moves from someday to on the horizon, protecting what you have already built becomes just as important as growing it. That's where Noble Gold Investments come in, helping investors reduce risk by adding physical gold to their portfolios. Right now may be a smart time to talk with Noble Gold Investments. No pressure, no sales gimmick, just clear answers and strategy built around our goals. Visit x22gold.com and build your portfolio for the long term. That's x22gold.com, or just click the link in the description. And remember, past performance may not be indicative of future results. Investing in precious metals involves risk. Consult your financial advisor before making investment decisions. Let's get right into the economic collapse financial news. Now, the deep state, the corrupt politicians, the private West Central Bank, the World Economic Forum, you can see that the private West Central Bank, they are now panicking because Trump and team, they are now exposing the entire central bank system. And you can see all the central bankers, they're pushing against this. There are rhinos and D's and the fake news. They're all pushing against this because once again, they're all in line with the central bank, and they've been set up to do what? To protect the central bank system because they profit from the central bank system. So all the people that have been brought into this government who have been installed, I'm not talking about the elected people, but the people that have actually been installed, these people are set up to make sure that there's never an audit. They always protect, and they make sure that nobody's actually talking about the central bank system. But Trump, he's going to be exposing the central bank system to show the people the truth, to show the people, look, this private organization, they've been running this country. They're not elected. And do we really need them? Does this go against the Constitution? Does it violate the Constitution? And absolutely it does. And I do believe this is why Trump has started the narrative right now. And actually, as he started the narrative, you could see that gold prices are starting to move up. Now, yes, we're going to see fluctuations in the gold prices, just like we see fluctuation in the Bitcoin. But when you step back and you take the 40,000 foot view, what do you see? You see Bitcoin has been going up. You see gold has been going up. You see silver has been going up. And I do believe this is what Trump is now doing. He's showing the world the truth about the private West central bank system to bring this country back to the Constitution. And I do believe at this point in time, you could see that the deep state players, the World Economic Forum, the central bank, their plan to bring us into the Green New Scam, the Great Reset, well, it's now being exposed. And of course, those people that said, oh, look, they're going to track your mileage. They're going to control the electricity. They're going to shut off your devices. They're going to shut down your bank accounts. Well, those were conspiracies. And every day that passes, it seems that the conspiracies, once again, they're coming true. All you got to do is look at Massachusetts, and this should tell you everything you need to know. Because again, in these blue states, the central bank, the deep state players, the World Economic Forum, what they do is they push their agenda slowly, quietly, and they do it in these different areas. And eventually what happens is it spreads across the country. I mean, when Biden came into office, you could see he went all out and pushing the Green New Scam because, again, they were way behind schedule. They never expected Trump to win the election in 2016, and they had to catch up. And by doing this, by accelerating their plan, they showed the world what they were planning to do. And all you got to do is look at Massachusetts, because the Massachusetts Democrats, they're moving to limit miles people can drive because of climate change. Libs of TikTok put this out and said, SB 2246, introduced by State Senator Cindy Cream, can limit people's personal car use and mileage they are allowed to drive. The bill already passed the Joint Committee on Telecommunications, Utilities, and Energy, and now heads to the Senate Ways and Means Committee. So that conspiracy where they wanted to control how far you drove is no longer a conspiracy. It is truth. Now, think about why they were pushing electric cars. Because again, in the end, they weren't going to give everyone an electric car. They wanted very few people using electric cars. And with those electric cars, you wouldn't be able to travel very, very far. Remember, the entire grid was going to be powered not by oil, not by gas, not by nuclear power. It was going to be powered by what? Solar and windmill. So basically what they were going to do is they were going to trap people in 15-minute cities. They didn't want people traveling outside of there. And they didn't want people flying on planes. So if you had an electric plane, they aren't very efficient. You can't carry that many people. You can't go that far. This was their plan. And now it's being exposed. And you can see out in these blue states, they're still trying to push it. And as they push it, those in the red states, and even those people that don't agree with it in the blue states, they're going to say, absolutely not. This is absolutely ridiculous. I mean, all you got to do is look at Manhattan. Under the guise of congestion, they decided to implement a tax to stop people from driving into Manhattan, and they wanted the people to use mass transportation. Now, of course, people say, well, that's good. This way we don't have traffic. Oh, it's good. This way we save energy. No, this was part of their plan to make sure that you aren't driving, that you're not independent. You're dependent on the government. And this is why they put these things into place. Trump, he put this out on Truth. He said the following: congestion pricing in Manhattan is a disaster for New York. It's got to be ended immediately. It's never worked before, and it will never work now. I love New York and hate to see it being destroyed so rapidly with such obviously foolish policy. Thank you for your attention to this matter, President Donald J. Trump. And he's absolutely right. And they do this for one specific reason. They do it because they're pushing their agenda. Remember, they don't want people traveling around. They don't want people using gas. They don't want people using any type of energy except solar and wind power. And once again, those aren't reliable sources of power. And this is why you see, when you look at California, when you look at Germany. This is why you see the businesses in the state and the country. This is why businesses are moving out of there. This is why they're saying, you know, something, we can't manufacture here. This is a complete and utter disaster. And this is why you see electricity costs skyrocketing, because that's what this causes. Trump, he put this out, said, under sleepy Joe Biden and the radical left Democrats, the average American household's monthly utility bills went up massively, over 30%. I never want Americans to pay higher electricity bills because of data centers. Therefore, my administration is working with major American technology companies to secure their commitment to the American people. And we will have much to announce in the coming weeks. First up is Microsoft, who my team has been working with and which will make major changes beginning this week to ensure that Americans don't pick up the tab for their power consumption in the form of paying higher utility bills. We are the hottest country in the world and number one in AI. Data centers are a key to that boom and keeping Americans free and secure. But the big technology companies who build them must pay their own way. Thank you and congratulations to Microsoft. More to come soon, President DJT. And yes, these data centers, they will have their own power source, either a fusion center, nuclear, or something else. And they're going to pay their own bills. It will only be used most likely for that entire complex. And the people across the country, they will not be involved in this. And this is the way the data centers will not be driving up the cost for everyone and making everyone pay. And this is going to be very, very.
This is what happens to a 40-year-old man when he only washes his hair with a DHT blocking shampoo. After 2 weeks,
interesting, because you have to remember what Trump is doing right now. He's prepping and planning for the midterms because he knows we need to win the midterms. So if you make the economy, while you're playing in the central bank illusionary economy, if you make the economy absolutely incredible and you give the buying power back to the people are going to be very happy, because once people have the buying power and they can buy a house, they can pay their bills, they can fill up their car. And when people can get an incredible job, people feel good. They don't want to go back to the way it was. And that's what Trump is doing right now. And one of the things that he's doing is he's capping the credit card interest rates, and he wants it at 10%. Now, how he's going to do that, that's going to be very, very interesting. But this is what he put out on Truth. Please be informed that we will no longer let the American public be ripped off by credit card companies that are charging interest rates of 20 to 30% and even more, which festered unimpeded during the sleepy Joe Biden administration. Affordability, effective January 20th, 2026. I, as President of the United States, am calling for a one-year cap on credit card interest rates of 10%. Coincidentally, the January 20th date will coincide with the one-year anniversary of the historic and very successful Trump administration. Thank you for your attention to this matter. Make America great again. Now, the question is, why did the Biden administration allow the credit card rates to go up? Well, it wasn't an accident, because what happens when you just borrow and borrow and borrow and you put more currency into circulation? You devalue the currency, and then you see inflation. So people use the credit card even more. And then what happened? The rates had to go up to control inflation, which means the credit card rates went up. They caused all of this. They're the ones who created this mess. And again, just like the credit cards, they're a loan sharking operation. And once again, why would you need credit cards? Think about this for a second. Try to live without your credit cards. Try to live without lease payments, financing, and things like that. Ask yourself a simple question. Why do I need a credit card? Why do I need payments? Why has all this come into play? Because as the currency devalues, what do you have to do? You need more of those pieces of paper to pay for that same item. And that item sometimes is out of reach for people, because those people that are making less, they find it very, very difficult. Even those people that are in the middle range, they're finding it difficult. And eventually what happens is that, wait a minute, to afford this car, I no longer can just finance it. Now I have to lease it. To afford these products, now I have to have payments. And what do? They use their credit cards, or they go on some type of payment plan. That is because the central bank system is breaking down. It's because the currency is devaluing, and they have to bring in alternatives. Because think about it. If you go back to 1971, and the central bank didn't bring in alternatives, they kept manufacturing in this country. They didn't introduce credit cards. There are no payment plans. There's no financing. There's nothing like that whatsoever. from 1971 moving forward, as we came off the gold standard, what happened? The value of the currency declined. We saw inflation. Now, if those manufacturers were still in this country, what would happen? Everything they produce would be very, very expensive. Like the shirts or a hat or socks, they'd be very, very expensive. And when you look at food, it would be the same thing. So people wouldn't be able to afford any of this because they wouldn't have a credit card. They would have to use their cash, and they would run out of cash and they wouldn't be able to survive. So to basically, hey, listen, if you're over 40 and planning to retire someday, the window to protect what you've built may be smaller than you realize. Here's a question most people never ask. Is your portfolio built for what's coming next? Many investors in their 40s and 50s discover they have little to no exposure to precious metals. That means their savings are largely tied to markets, policies, and paper assets with very little protection if conditions change. As retirement moves from someday to on the horizon, protecting what you have already built becomes just as important as growing it. That's where Noble Gold Investments come in, helping investors reduce risk by adding physical gold to their portfolios. Right now may be a smart time to talk with Noble Gold Investments. No pressure, no sales gimmick, just clear answers and strategy built around our goals. Visit x22gold.com and build your portfolio for the long term. That's x22gold.com, or just click the link in the description. And remember, past performance may not be indicative of future results. Investing in precious metals involves risk. Consult your financial advisor before making investment decisions. Mitigate all this. The central bank had to think of a way to convince people that nothing's changing. You know what? We will introduce credit cards. And it's great. You can get a loan without even applying, really. Here you go. You can go ahead and use it. Let's move the manufacturers out of this country. We'll bring back those products because we have slave labor in other countries. We'll bring it back. There'll be no tariffs whatsoever. People won't even know the difference. This is what they did. They tricked the people from the very, very beginning. And now people see the truth. And you have to remember, inflation, when they talk about 2%, 2.5, 2.6, 2.7, they're just talking about inflation during this time period. They're not talking about the cumulative inflation, because if you go back to 1971 and you move forward, when we came off the gold standard in 1971, we have about 3,000% inflation. Because if we truly went back to 2% inflation, we would be 2% above what it was in 1971. So whatever the prices were back then, we'd be 2% or 2.5% above that. But we are not. We're 3,000% above that. So when you talk about inflation, you're really talking about this year. And this is what the Fed convinces everyone that they have everything under control, which they do not. Actually, they're way out of their mandate. The Kobisi letter on X put this out and said the December CPI inflation comes in at 2.7%, in line with the expectations of 2.7%. Core CPI inflation comes in at 2.6%, below expectations of 2.7%. Both headline and core CPI inflation were flat in December. Now, again, Trump is playing the game, and he's saying to the Fed, look, I'm getting close to where you want it to be. The people now see it. They're close to where it needs to be. Now, again, what is he actually doing? He's making sure that the value of the dollar is stabilized. But all that other inflation that we've experienced before Trump, it's still there. So moving forward, he wants to make sure that everything is not going up and he's able to stabilize the value of the currency. At the same time, he is lowering fuel prices, which gives people more money, puts more money back into their pockets, which they can counter the inflation that they already experienced. When he starts to remove the income tax, that will also give the buying power back to the people. And I do believe what he has done right now is he started the narrative for the central bank system. Remember, this is the third one we have in this country. The first one, the charter ran out and Congress said no more. Andrew Jackson, for the second one, ran on the platform of getting rid of the central bank, and he got rid of the central bank and went to tariffs. Now Trump is battling the third one, and once he gets rid of it, we will go full tariff. Actually, that's why Trump is building the tariff system, which I call the parallel economic system. And it seems that Trump now just hit Powell once again and put this out on Truth. It said, just out, great low inflation numbers for the USA. That means that Jerome Too Late Powell should cut interest rates meaningfully. If he doesn't, he will just continue to be too late. Also, out, great growth numbers. Thank you, Mr. Tariff, President DJT. And he's absolutely right. It's time to bring the rates down. Now, think about it. He brings the rates down. It's going to help automobile manufacturers. It's going to allow the credit card companies to bring the rates down, even though Trump is saying bring it down to 10% right now for a year. Very interesting time frame. You're going to see housing start to boom because as the interest rates come down, more and more people can purchase homes. Businesses can expand with lower rates. So Trump, he is pushing the Fed, using their system against them to actually spur economic activity. At the same time, he is now exposing the central bank and waking the people up so they understand what the central bank actually is. And Julie Kelly pretty much like kicks it off and says, granted, I'm not a math or numbers person, but I've done a lot of digging into the Fed over the past several months and claims of its independence while wielding tremendous power over the American people. Just someone make this make sense.
Watch what happens when a 50-year-old man blocks DHT naturally for just 90 days. Day one.
And how a handful of unelected people control this much money, really, all of our money. I am totally open to someone explaining to me and the average American how this is possible. Also, where the funding comes from to run a $1 billion board of governors and a $6 billion Federal Reserve System on top of all the money the Fed is stewards of. What exactly is going on? And why are so many Republicans, Tillis, Murkowski, and Democrats, Warren, Jeffries, Murphy, so quickly coming to Powell's rescue? Like so many things, Trump and his team bringing to light the insidious rule of quasi-government agencies over all of us. And that is absolutely true because the central bank system is a private corporation. They control the creation of currency. They took it away from we, the people. The founders said, no, the people have the right to coin money. And the Fed, well, they took that away from us. And it's the third time they have done this. And if you go back in time, they've done this in many, many countries. Their system doesn't work for the people. The system works for them and the elite. And now Trump is exposing the Federal Reserve and saying, listen, if they can't manage their own projects, if they go over budget, how in the world are they managing the U.S. economy? And Trump continually calls them out on all of this. They've been wrong about everything, if you really think about it. Remember, during the Biden/Obama administration, we had Janet Yellen, head of the Treasury. We had Jerome Powell out there saying, oh, there's no inflation. Don't worry, inflation's going to go away in the summer. Don't worry, everything's under control. And it wasn't. Now, during the Trump administration, they said tariffs are going to cause crazy inflation. Just wait for the summer. Just wait for the fall. Just wait for the winter. And it never showed up. Because, again, the only thing that causes inflation is putting the Federal Reserve note into circulation, diluting the currency. And as you dilute the currency, it loses value. You need more of those pieces of paper to pay for the same exact item. So again, they're trying to get around this, but it's not working. Jerome Thorne put this out and said, this doesn't meet the smell test. Powell and his allies are using the language of independence to turn a basic oversight dispute into a political morality play, and it looks increasingly like an attempt to delegitimize any legal scrutiny of the Fed. This has all the elements of a hoax. What Powell actually did. Powell chose to go public with a dramatic video statement saying DOJ subpoenas threaten a criminal indictment over his testimony on the Fed's multi-billion-dollar building renovations. He explicitly framed the subpoenas as pretext and cast them as retaliation for the Fed setting rates independently of the president, evaluating a renovation cost overrun inquiry into an existential attack on the central bank independence. The framing of criminal indictment came from Powell and what looked like a scripted response. All of the Fed acolytes on Wall Street cried foul.
7 minutes.
They bought in hook, line, and sinker what the U.S. attorney is saying. The U.S. Attorney's Office for D.C. has stated they contacted the Fed on multiple occasions about cost overruns, and Powell's congressional testimony were ignored and therefore resorted to a formal legal process, which they stress is not a threat. Janine Pirro has been explicit that the word indictment has come out of Mr. Powell's mouth, no one else's, and that none of this would have happened if they had just responded to our outreach. Powell now publicly insists no one is above the law, even as the record shows the Fed disregarded informal outreach and only engaged once grand jury subpoenas landed, which is the opposite of transparent cooperation. Recall Choke Point 2.0 and unbanking of individuals? By recasting a straightforward question of cost overruns and a possible misstatement to Congress as an illegitimate criminal indictment threat, Powell is effectively demanding a special zone of immunity wrapped in the rhetoric of independence. Why central bankers are charging the hill. Former Fed chairs and global monetary grandees have rushed out statements condemning the probe as an attack on Fed independence, treating any prosecutorial look at a central banker as inherently out of bounds. Are they getting scared? Are they panicking? Yeah, they are. The former Fed official statement is doing exactly what the 51 Intel official's letter did on the Hunter Biden laptop, using elite signatures to launder a political narrative into institutional dogma and declare scrutiny itself illegitimate. Powell and his allies are recasting a narrow DOJ inquiry into cost overruns and testimony accuracy as an existential assault on independence. And an all too willing media is once again treating the letter as revealed truth instead of asking hard questions. This closes ranks around the idea that the central bank sits on a higher plane than normal agencies, immune not only from political pressure on rates, which is legitimate, but also from standard legal and fiscal oversight, which is not. Mainstream media and the death of the fourth estate. Much of legacy media has adopted Powell's framing, almost verbatim. Unprecedented attack on independence, monetary policy under assault, while relegating the core factual dispute, ignored outreach, cost overruns, accuracy of testimony to secondary status. Powell and the central bank crowd are behaving in a way that is frankly odd. They stonewall basic oversight, scream independence the moment anyone reaches for legal tools, and acts as though they stand above the law, while a compliant mainstream media gladly carries their narrative, proof the fourth estate has checked out. All this doesn't meet the smell test. Is the Fed above the U.S. Constitution? Why did Powell go public and choose the framing that he did?
Under 5
Why
minutes.
did the mainstream media and the so-called objective pundits not do
We'll
any
get some
objective
short clips
analysis?
in.
Smells like elements of Russia hoax strategy to me. The reason why they've basically went on the defensive is because they understand what Trump is about to do. They understand in the end, Trump is building the tariff system to basically take down the central bank system. That's the only reason you build the tariff system. And now they're in the position, actually Trump kind of forced them into this position by tricking them. And now you could see the mainstream media, you could see those people in Congress, you could see the other Fed heads, they're all now taking a side. Trump can see the board very, very clearly. So once again, you can see that Trump has now maneuvered in a way to set the central bank up. And while he's doing this, the people are wondering, why are they acting like this? What's going on? Why are they protecting the Fed like this? Why do they have to be independent? Something is up here. But Metalawn Man says 3 peculiarities about Jerome Powell's statement. Powell is the one who decided to disclose the existence of the grand jury subpoena, not the government. The government is generally prohibited from discussing grand jury proceedings. 2, contrary to Powell's statement, service of subpoena on the Fed is not a threat to indict him. Subpoenas are investigative tools. It's possible that the government separately advised Powell that he was a target of the investigation, but he didn't say that. 3, nowhere in the statement does Powell say his testimony to Congress about the Fed construction project was truthful and accurate. Very interesting. And U.S. Attorney Pirro, she says, listen, we just asked him a couple of questions. We never said anything about indictment. That all came from Powell. So right there, that tells you everything you need to know. You could see the deep state players, the central bankers, they're panicking. The battle has begun. And yes, the central bankers, they are now showing everyone in this country that no, we don't care what the people want. We are going to stay in control because they know what happens when they lose control. They lose control over everything because now the deep state players, the criminals, they can't get their money. And the central bank loses control over the people. And this is why Trump has started the tariff system, because the tariff system competes with the central bank system. The central bank takes currency internally, robs you of your labor. Trump is using the tariff system to bring in currency externally, and you get to keep the money that you earn from your labor. So right there, that should tell you everything you need to know, and it should tell you why the central bank is so panicked. And as more and more evidence is produced about the central bank, what do you think is going to happen with alternative currency, which is actually the true currency, gold, silver, Bitcoin? What do you think is going
This is what 92 hair washes can do in 6 months. Not 10 washes, not 30 washes.
to happen? Do you think they're going to drop? Or as more evidence is produced and information is brought out into the open and people start to learn what the central bank system is, you're going to see gold, silver, Bitcoin really start to move up. We're already starting to see the beginning of change. We're already starting to see Trump take a position where he's going to attack the central bank system and expose the central bank system. The battle has already begun. Listen, everyone, thanks a lot for listening. Be well, be safe, and especially be prepared. Thanks a lot.
Okay, that was yesterday's X2 report. Time for a short clip for a bit, and then we'll get to the 15-minute Billy.
Yes, I seen you guys on the street before.
We are going to come.
A 21-year-old victim attended a rally Friday night in Santa Ana to protest the deadly shooting of Renee Good in Minneapolis.
During the protests, they were shot point blank range with a less than lethal rubber bullet, resulting in life-changing injuries. KTLA's Mary Beth McDade is live in Orange County, where the victim's family and friends are demanding a stop to the violence and justice. MB.
Hi there, you guys. Yes, I spoke with Kay's father, who tells me that Kay has been released from the hospital and was out to dinner with friends when he and I were speaking. Now, he says that Kay will be permanently blinded in that eye and that there are still shards of glass, metal, and plastic lodged behind the eye because surgeons were unable to remove them. A group called Dare to Struggle were seen lighting an American flag on fire outside the federal building in Santa Ana Friday night. The far-left activist group were protesting the shooting in Minnesota of Renee Good. At some point, federal agents can be seen pulling a protester out of the crowd and dragging them away. With that, some fellow protesters go after them, including Kay, who was seen earlier near the flag burning. Kay's family and friends say Kay was hit in the eye by an agent's less than lethal round. You can clearly see the blood on Kay's face. Members of Dare to Struggle held a press conference Tuesday to discuss the violent incident and read a letter Kay wrote about their injuries.
I had to get surgery on my eye. I was told that my tear duct was destroyed. My lower eyelid was so messed up that they needed to take skin from my temples to repair it. My eye had sunken, the globe ruptured, and flaps of my eye barely holding on. My skull and eye socket is also fractured beyond repair, which is affecting my sinuses, and I will never see through my left eye again.
Sky Jones was the protester seen being arrested first by agents. Jones wouldn't talk about what led to their arrest.
We're not going to speak to anything beyond our statements about what the officers did.
DHS says that rioters threw rocks, bottles, and fireworks at law enforcement. And Kay's father says that we do need immigration reform and that people should be living in the country legally, but he says that there must be a civil and humane way to do so. For now, reporting live here in Orange, Mary Beth McDade. We'll send back to you guys in the studio.
Okay. Well, you shouldn't have been there.
Ilhan Omar, a woman who married her brother and committed federal
3 minutes.
immigration. It's a complete violation of federal immigration law, and that's the least of her problems. That's the best thing about her. Here she is announcing that the Democrat Congressional Progressive Caucus is going to try to defund ICE.
And so today, I am glad to announce that the Congressional Progressive Caucus has adopted an official position to hold ICE accountable. Our caucus members will oppose all funding for immigration enforcement in any appropriation bills until meaningful reforms are enacted to end militarized policing practices.
So, sorry, meaningful reforms. They're achieving their objectives. What would she like reformed? Their efficacy? Like, what is she talking about?
Well,
Why don't you reform the behavior of the idiotic protesters? And again, tragic what occurred, but they're causing the issues. She's insane.
To me, she should be denaturalized and deported.
Oh,
Putting aside the
chick.
marrying her brother thing, which I don't know how you feel about that, but
I mean, I've got a brother who, and he's gay, which,
yeah,
and I'm saying
that
that
would
as
be
though
very confusing. So you could get gay married to your own brother. Jesus.
I'm trying to say, would that make it less viable or attractive? I mean, either way, it's gross. I don't get it.
So
but-
she marries her brother, but putting
Yeah.
that aside, the reason I think she should be denaturalized and deported is because she's using her position as a sitting member of Congress to break the laws of the country that she swore to protect. It is the federal government's job to get these people out.
She's dangerous. She's dangerous. And I look at so many people that have come to Western nations, and we have the same thing in Australia as well. When you look at people who come and what I say is, come to our country, follow our rules and our laws, keep parts of your culture that are special to you. Absolutely. Don't try and change ours. Don't break our laws. Don't kill us. It's really simple. People flee countries and come to countries like Australia, like America, because they want what we offer: safety, peace, democracy. She's come to this country and she wants to destroy everything about it.
She wants to bring in the sectarian violence that she fled.
Exactly. It make sense.
That was a good short one, hockey. Finally. Okay. I got 2 Nick videos. Five minutes on this one.
Integrity. Now, this story is not getting a lot of coverage because this kind of thing really doesn't get clicks with the general public. But those of you that follow this channel, I know you guys are going to love this. So according to the Gateway Pundit, another victory for Tom Fitton and Judicial Watch. Oregon agrees to clean 800,000 names of inactive voters from voter rolls. Last June, Tom Fitton, the president of Judicial Watch, announced that his organization was suing Oregon to remove the names of inactive voters from the state's voter rolls. Here's what Tom said. Hey, everyone, huge news. Judicial Watch lawsuits led to the cleanup of 4 million dirty names from the voting rolls in just the last 2 years or so. And he's talking about other victories they've had in court against LA County, California, in New York. They've had several victories that resulted in the purging and cleanup of inactive voters in various states. And so now the grand total is like 5.8 million inactive voters have been removed thanks to Judicial Watch. And so the latest is the state of Oregon. Now, Judicial Watch says that 29 of Oregon's 36 counties removed few or no registrations as required by federal election law. And so they sued the state of Oregon under the National Voter Registration Act, which is a federal statute that requires that states maintain accurate voter registration lists. And if they don't clean up the voter rolls, then they are out of compliance with this federal statute. So what Judicial Watch did was they obtained publicly available data and found that Oregon and 35 of its counties had overall registration rates exceeding 100%, meaning there were more people on the voter rolls than there were eligible voters in the state. They say, frankly, Oregon has the highest known inactive registration rate of any state in the nation. Dirty voting rolls can mean dirty elections, and that is exactly right. We've learned over the years that having bloated voter rolls enables fraudsters to rig elections, because if you want to cast a fictitious ballot or a fake vote, you have to assign it to a voter on the registration list. And so if you have massively inflated voter rolls, then there are endless opportunities for you to create fictitious votes. Now, having accurate, clean, maintained voter rolls makes that much, much harder to do because there's fewer opportunities to assign fake votes to a registered voter. And Judicial Watch is using publicly available data to put these states on notice and take them to court and make them follow election law. Now, you may be thinking, what's the big deal here? We're talking about Oregon, which is a solidly blue state, and it's not like they're going to be voting for a Republican in the next presidential election. But I want you guys to think a little bit bigger here, because the midterm election is right around the corner, and there are tightly contested congressional districts in the state. For example, Oregon's 5th congressional district actually flipped from Republican to Democrat in the last election cycle. Janelle Bynum won by a razor-thin margin. And if there is a big problem with election fraud in Oregon and we just purge their voter rolls, making it more difficult for them to cheat, then this could flip back to Republican in the 2026 midterms. Also, Oregon's 4th and 6th congressional district are also fairly tight, not as tight as the 5th district, but still it's within a margin that could be flipped if we clean up election fraud in the state. Not to mention the tons and tons of down ballot races, the state legislature. There's a lot of things that can be impacted by cleaning up the voter rolls and therefore reducing the amount of fraud in the state. Now, bear in mind with this story, putting it into a broader context, that the DOJ is currently suing the state of Oregon, as well as 22 other states, for failing to provide the metadata as to the who, what, where, when, and why they have maintained accurate voter rolls. They're refusing to turn this stuff over to the DOJ because they know that they're not in compliance with the National Voter Registration Act and have been allowing their voter rolls to become bloated. And therefore, what could happen now that they've agreed that they had 800,000 ineligible voters still on their active voter rolls, this could be grounds for the DOJ to prosecute people criminally. This is absolutely relevant to the DOJ's own pursuit in finding out how these states have been managing their voter rolls and finding gross mismanagement, negligence, or intentional corruption. So, ladies and gentlemen, this is a big story, but it's not getting a lot of coverage. This is something that's not going to get me a lot of views, but I wanted to bring it to your attention because I know a lot of you guys out there care deeply about this as well as I do. So, ladies and gentlemen, this is a major victory from Judicial Watch. And of course, I wanted to amplify this so that you guys know the groups and the organizations that are fighting for election integrity, in case you wanted to support them financially, or if you wanted to follow them on social media or whatever, to make sure that we are backing the people that are doing the real work. So, ladies and gentlemen.
Okay, that's first one. I'm going to do one of this lady. I haven't done in a while, that new lady on TikTok. And then I'm going to get to Billy Bean. She's a new lady.
On the business end of a very ugly order from Judge Paige Whitaker, not in any way flattering to their lawyering skills. So let me break it down for you. And yes, it was also a bad week, by the way, because the attorney's fees are rolling in the case against the president. I'm going to do a separate video about that. But today I want to tell you about the massive screw ups of the Young Thug trial. And this is new stuff that has just happened in the last few months. If you haven't followed the Young Thug trial, that's all right. You don't really need to know much about it. Jeffrey Williams is the rapper known as Young Thug. He and several other young men were charged by Fani Willis in a RICO indictment. And many of the underlying acts that she alleged, including things as serious as unaliving someone, didn't really end up with any major convictions. She has tried to spin it as if this ridiculous waste of time and money ended up having some positive result. But in reality, pretty much every legal expert will tell you that the trial was a massive failure. But there's a whole nother side of this. So when back in May of 2022, the state executed a search warrant, they ended up seizing a whole bunch of Young Thug's property, including cash, jewelry, cars, some weapons, a whole bunch of things. I couldn't even begin to tell you what the total amount was. The cash alone was over $150,000. So they then, in July of 2022, filed a complaint for forfeiture, saying that they believed that all of these things that they had seized from Young Thug were the result of criminal acts, and therefore Young Thug should not be allowed to have them, and that the state should get them. So, of course, the first thing we need to point out is when the state is successful, or in this case, the district attorney's office is successful in getting forfeiture, they get to keep a large portion, sometimes all of what they seize. So you can see from the beginning, I am just ill whenever I have to talk about forfeiture proceedings like this, because it's incredibly suspicious that the state has their own monetary interest in getting people's property.
Yeah, remember this one?
Other big problem from the
this
start
lady that we
should be
did a while back.
that anybody, you don't even have to be a fan of Young Thug, you should be outraged that the district attorney's office would assume that this young man, this Black young man, only got his property because he was an alleged criminal and not because he's a massively successful music artist. So it's outrageous and insulting from the beginning. Now, in July of 2022, I also want to remind you all that just a little while after that, Nathan Wade was paid by Fonnie Willis's office through the civil forfeiture funding of her office. No one's really ever dug down on that. But that in and of itself is also so fishy, because this is a guy she was sleeping with and he was paid out of that fund. But I digress. Let's go back. So now we know the state has filed this forfeiture action, and they are saying we want to be able to keep these things, and it has to go through a court hearing. But when that got filed in July of 2022, of course, this massive case was in the middle of ramping up. So the judge stayed it. I mean, the judge said, we'll put a pause on it. We'll deal with it once the case against Mr. Williams is over. All right. So now we fast forward all the way to October of 2024. In October of 2024, Jeffrey Williams, as many people know, took a plea. He's out on probation. He's not spending any more time in custody. So that was the time that triggered this statute saying, all right, to the district attorney's office, you guys want to get this property, you want to keep it, you got to have a hearing in 60 days. And they did not do that. So we fast forward to August of 2025, when Brian Steele brings up to the court and says, look, they can't have this property now. They were supposed to have a hearing within 60 days. They screwed up. They didn't get the property. We get to have it dismissed, and we want all his stuff back. This was back in August. So now we've seen already the state has screwed up by not getting the hearing filed in time. The judge in August agreed. The judge said, you're right. They had 60 days. They didn't do that. You guys have to give Mr. Williams his stuff back. The state said, whoa, whoa, whoa. We want to appeal. We want to ask the Court of Appeals to look at this. Now, let me give you a really quick aside, because this is important. When they had that hearing where Brian Steele said, too bad for you, the court had let them know in advance, look, I'm not going to have a court reporter there. That's not uncommon in civil matters. It's very different. This is a civil matter that's very different than the criminal matters, where whenever anything substantive is happening, there's a court reporter there taking it down. But you as a party in this civil forfeiture, you can have your own court reporter there if you want to. Well, Brian Steele wisely said, I want a court reporter there. And it costs money to have a court reporter there. So he emailed the state and said, would you all like to share in the cost of having a court reporter for this forfeiture hearing? And the state never responded. So Brian went, okay, I'll pay for my own court reporter. Court reporter's there. Court reporter takes down the transcript. The state loses. And so, like I said, the state says, whoa, 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 we don't want to give that property back. We're going to appeal to the Court of Appeals and see if we can get Judge Whitaker's ruling overruled. Now, they only have, by statute, 30 days to get everything pushed up to the Court of Appeals. And that includes the transcript. When the state filed their notice of appeal, they only have 30 days to do that. Right when that 30 days was about to end, they said, oh, the court reporter's not done with the transcript yet. They went to Judge Whitaker and said, can we have another 30 days? But here's what's funny. When they filed the motion to ask for more time, which they're allowed to do, they never sent a copy to Judge Whitaker. They just filed it with the clerk. And Judge Whitaker has an order. A lot of judges have a rule on a motion. You kind of got to let them know that one's out there, because they don't get notified when it gets filed with the clerk's office. They never filed it with her, so she didn't know about it. They tick tock, time goes by. They realize that they still don't have the transcript. They file another motion and still don't copy Judge Whitaker on it. So now we've moved all the way to, November of 2025. The judge just so happens to be looking through the docket and realizes,
is she okay?
What are these extension motions? Are you kidding me? So she says, all right, I'm going to give you till, I think it was like December 19th. Make sure the court reporter gets it finished and up to the Court of Appeals. You guys can have your appeal. Ha ha. Guess who had never even asked the court reporter to prepare the transcript? That's right, the state. Even though the state knew who the court reporter was, they had asked Brian Steele back in September and he told them who it was. They never ordered a transcript. So all that they had been saying to Judge Whitaker in these written motions, we think the transcripts will be done in 30 days. Oh, no, wait, we think they'll be done in 30 more days. They'd never even asked for the transcripts. And there was actually an affidavit from the court reporter saying, hey, they've never contacted me for these transcripts, so I don't have them. And oh, by the way, remember how they never paid for it and Brian Steele had to shoulder the cost? The court reporter said, actually, since they didn't pay for us, we're not giving them a transcript at all, which is kind of hilarious, actually. So Judge Whitaker is made notice or is made aware of this because Brian Steele filed something in December saying they never even ordered a transcript. Why are we still playing games? This cannot be appealed. They've never even done what they said they were going to do. So Judge Whitaker issued an order this past week, a scathing order, talking about everything I just told you, laying out all of the times that the district attorney's office screwed this up. They had multiple opportunities. They screwed up the 60-day hearing. They never got the transcripts. They made it seem to the court like they had gotten the transcripts. So they're scrambling now, right? And they did try to argue to the judge, look, yes, we screwed up. They admitted that they screwed up multiple times. But they said, look, we didn't do it out of malice. But malice is irrelevant. It's not about malice. I'm looking for the exact wording. It's unreasonable and inexcusable delay. And the judge said, yeah, you qualify. This was an unreasonable delay on your part and inexcusable behavior. And she chucked the whole thing.
I want to play DJ,
so now they have no
Derek
way
Johnson before
to
Billy.
appeal giving back
Right.
Young Thug his property. And so she issued this order on January 7th, and she gave them until January 9th at 5 p.m. to give him back all of the things that she had listed. I do want to make it clear that there were some things that she described as things that no one had ever claimed. So there was kind of two different buckets of stuff. There was about $5,000 and there was some weaponry. There was a little bit more. I think it was totaling about $50,000 of stuff that the state did get to keep through the forfeiture. But the bulk of the things that they wanted from Thug, the $150,000, the luxury cars, the jewelry, all that stuff that you just know, Fonnie Willis had dollar signs in her eyes about how she was going to be spending all that money on her office, of course. She doesn't get it now. And so my understanding from looking through social media and such that Young Thug did eventually this past week get his stuff back before that Friday deadline. However, of course, we have to mention the one other thing that everyone wants to talk about, which is the watch. So if you don't know, there was a Richard Mille watch that Young Thug owned, a luxury fancy watch that had been discussed on body camera when they were executing the search warrant. The investigator mentioned it, but it was never cataloged as something that was seized. And now nobody knows where it is. So it's not on the list of things that is supposed to be returned to Thug because the state's position has always been, we never had it. But it was there 1 minute, the cops come in, and now it's gone. Could it have been stolen by somebody else? Of course. But if you did watch the YSL trial and you saw how shady the behavior was of a lot of the people, both testifying for the state and lawyering for the state, I do have to say, normally I would say, look, prosecutors don't do stuff like that. Investigators don't do stuff like that. I've got a bad taste in my mouth about the YSL case, so I just can't say for sure where the watch went, but we still don't know. And one more thing I want to talk about with regard to Fonnie Willis, her screw-ups, and how people see them is this. A shout out to my friend Holly Waltman, who's another criminal defense lawyer and a friend of mine. She commented on what I just told y'all about for local news, and she said it in a really great way. And I'm going to paraphrase what she said. if you are someone who thought that Young Thug and his co-defendants were these awful, terrible criminals, just like Fani Willis had pointed them out as being, then you should be really angry with Fani Willis's office, because if that stuff really was ill-gotten gain through crimes, then you should be outraged that the state screwed up so bad to not get those assets, okay? So if you are a defender of Fani Willis and you believe that she did the right, treated Jeffrey Williams and his co-defendants, you should be pissed that she screwed this. On the other hand, if you are someone, you don't have to be a fan, someone who, like me, looked at this trial and said, this is an way that you have treated these young men. This was such an embarrassment to Fulton County and to Georgia and the application of the RICO law. You should be really angry that he had, and these other young men, dragged through the mud, paying for lawyers, having your property taken, and then not only them refusing to give it back, but screwing up and basically misleading the court to try to drag out an appeal to keep your stuff. So if you're a defender of Fani Willis, I'm not sure where you go here, because it's pretty horrendous. And of course, you know, knowing Fani, she'll try to blame her associates, her assistant district attorneys for this fraud. But let's remember that she's the one that really likes to be in front of media on her little podium, talking about all the great things she's doing. So she loves to take the credit, but she's not so great at taking the responsibility. And if you're a good manager, if you're a good leader, you're not going to blame the people below you when there's a massive screw up like this. So she needs to be the one to take it on the chin for this, because it's embarrassingly bad. So I hope that helps you kind of understand what this drama was that people have been talking about this last week. Congratulations to Young Thug for finally getting his property back. Civil forfeiture is an ugly and awful area of Georgia law, and these things aren't uncommon.
So she's pretty good. She's new on TikTok. So I'm going to play a couple short ones, I think, and then Billy, and then I'm going to finish the last two. I got two George videos. Oh, they won't let me. Shoot. I don't know why they can't let me play it. Darn it. I can't play this one. And sorry. Darn it. Well, I got this one. We'll get this out of the way. This one's 15 minutes.
It's about 3 p.m. Some of the things we'll cover. The U.S. Appears to be actively in war prep. We're seeing a cell phone outage. We're seeing an FBI raid the home of a Washington Post reporter. We're seeing President Trump taking action and, words intending to take action against taking Greenland. We see NATO now turning on the U.S. Tim Walz will be impeached, and it appears that a hit by the U.S. and Israel may occur tonight. So let's get started. We have this going on, Breitbart. So Tuesday night, we had a search warrant from the DOJ at the request of the Department of War to search the home of Washington Post reporter Hannah Natasan, who it's believed was receiving classified military information from a U.S. military contractor, Aurelio Perez Luganes. This contractor was from Maryland. He was a cyber expert, a system administrator, and the FBI also raided his home and office and found classified documents in both his lunchbox and at his home basement. If you hear that, that's my cat protesting something. So that's going on. We know as a nation prepares to engage in military conflicts that there is a heightened awareness of protecting classified information. And we're seeing today a cell phone outage. I submit that's part of the military's clampdown in its prep to begin military operations. We know most likely against Iran and possibly against Greenland. So we had a statement this morning by the DOJ, Pam Bondi, regarding the search warrant and the FBI raid on the Washington Post reporter's home, as well as the information coming out about the military contractor who was passing classified information and documents to the Washington Post reporter. So that's going on. And we have this. So I put forth in my previous video today regarding the Federal Reserve that is not a part of the U.S. government, but is controlled out of the UK City of London Deep State Financial Center. And it appears that the deep state is worried about the actions President Trump is taking against the Fed. We know Sunday night, the leader of the Federal Reserve, Jerome Powell, made a public statement about a subpoena he had received from the DOJ. And as I put forth, he had been called before Congress to give Congress additional information about $1 billion lost or not known where it was regarding a renovation of the Federal Reserve building. The subpoena, however, does not address money for the building, but rather Jerome Powell is being indicted for lying to Congress. And we see the deep state financial center that's over the Federal Reserve and other central banks inside the U.S. and other nations is worried that the American people are now going to realize that the Federal Reserve is not a part of the U.S. government, but is controlled by a foreign group of individuals out of the City of London. So that's going on. And we have this. We have that the Minnesota governor, Tim Walz, we're familiar with the information that's come out in the past weeks about the billion dollar fraud, primarily by Somali nationals, that took place inside the state of Minnesota, and that there had been a concerted and detailed and documented cover-up by the governor on down. Now, the Congress of Minnesota has brought 4 articles of impeachment against Governor Walz, and I've been hearing for weeks that Walz would be forced to resign this current second term. We know he declined to run for a third term. Some of the things he's being charged with by the Congress in their articles of impeachment is that he allowed the fraud to continue even after he had many reliable, credible warnings, and that he engaged in a cover-up of the fraud, and that he allowed Minnesota government agencies to continue the fraud. So that's going on. And we have this from W77. Yes, there's been a major outage today of multiple cell phone companies, Verizon, AT&T, T-Mobile Plus. I submit that this is part of the U.S. government's prep for military conflict, and that there is a top-down operation now regarding cell phone calls. The cell phones apparently can still send text, but they cannot make phone calls. And we have this from Dr. William Mount. President Trump has, his actions have slowed inflation in the U.S. And this is coming out. The U.S. Post Office today just came out that they will no longer accept cash, only, credit or debit card payments. And last Thursday, we became aware that the U.S. Post Office had put out a letter to its workers and contractors to carry the letter with them and also their ID in the event that the U.S. goes to a lockdown, so they could ID themselves as essential workers to law enforcement. We're seeing a currency collapse in Venezuela and Ukraine. And the question now is, what's going to come about with President Trump's moves against the Federal Reserve with regard to the U.S. currency? That is unknown. And we have this. Yes, regarding Greenland. Before the Greenland meeting, President Trump this morning on Truth Social posted that the U.S. needs Greenland for American security.
Finance the old way. Finance the ramp way.
So tasty, it could make Poseidon switch to a spoon. Holy divine taste from the Greek gods.
And that any other option is unacceptable. And now we hear NATO has turned against the U.S., and many nations in NATO are sending their military to protect Greenland from the U.S. military. This includes Denmark, Sweden, France, and Germany. And as I said, I don't believe the combined militaries could stand up to one battle against the U.S. military. And we have this. So there was a meeting today, J.D. Vance, Marco Rubio, Steve Witkoff with the foreign ministers from Greenland and Denmark regarding the U.S. taking Greenland. And Hal Turner's intel is that when the meeting was over with, and oh yes, one other thing, before the meeting, so in the morning, President Trump posted on Truth Social, the U.S. needs Greenland for U.S. security. Before the meeting also, President Trump contacted Rutte, the leader of NATO, for NATO to send in military forces to remove the Denmark military from Greenland. So then, we had the meeting, and when the meeting was over with and the foreign ministers from Greenland and Denmark came out of the meeting, they looked visibly angry. And they went on to make a public press statement that they were in disagreement with the U.S. So now we see Rutte, leader of NATO, turning against the U.S. Apparently, he received this phone call from President Trump, then advised all the other NATO members. And now a group of European nations are sending their militaries to Greenland. What are they going to do against the U.S. military? And that would include Denmark, Sweden, France, Germany. So that's going on. And we can look for the U.S. military to also be actively engaged, I believe, in taking Greenland. Now, these foreign ministers from Greenland and Denmark both told President Trump, lying straight to his face, that there was no danger of China and Russia taking Greenland. And yet, as I brought out, the Denmark Intel Service released an intel report stating that both China and Russia had plans to take Greenland by force. So, way to go, President Trump. We need to take Greenland now. And we have this from Alex Cristoforo regarding Greenland, that the discussion about Greenland is not over, not by a long shot. Now we see them sending their militaries. And we have this about Iran, also intel, U.S. intel, today, a little bit ago, that an Israeli brigadier general had made a statement regarding Iran, that it's highly likely that the U.S. and Israel will strike Iran. Other sources are coming out and saying possibly tonight. So that would go along with the cell phone outage we're seeing in the U.S. And we're hearing reports about what's going on in Iran. Elites are evacuating. Iran military has thousands of defections. In other words, soldiers in the Iranian military are leaving the military and siding with the people. And the police force is divided. Half are with the government and half are with the people. The Ayatollah and the mullahs are hidden away in an underground bunker on the east side of Iran, bordering Afghanistan. So it's good to be in prayer for America, President Trump, the U.S. military, and world peace. I love you, and I'll see you soon.
Okay. So this afternoon I did a show, and we had Billy on. It was 47 minutes. I did, so that big one was good. I got 2 photos, then I got 2 George, and then the death clock. I'm not sure it's a new one or not, but we'll check it out. We'll call it after we get these last 4 things in. So guess who bought a home in Malibu? They said here Harris bought $8 million mega mansion in Malibu. That's kind of odd. Wonder where she got that kind of money. So the list is out again, you guys. You guys remember this? Well, Detroit's on there. Houston's in there. Okay, there on the right side, it shows Dallas. They're dark. And Portland. I wonder if that means that's a checkoff. They got 2 done already. Of course, Chicago should be done. That's the list. God dang it. All right, see where we're at now. Okay. Let's do the duck clock first and see if we played this or not.
Right now. Today, silver topped out at $92. Now
this a new
today
one?
is the 14th, and we got this US Debt Clock message that said, should Doge audit Fort Knox gold reserve, which we've seen this before and it still hasn't been done, but it is interesting that they posted this today because it's the 14th, and tomorrow we will know
It's a
if
new one,
this
you guys.
Clarity Act will be passed or not, and tomorrow is the 15th. We know the Clarity Act would push forward a new asset-backed financial system by clearing defining digital assets and the regulatory treatment, allowing tokenized commodities, real-world assets, and reserve-backed instruments to operate legally outside of speculative fiat-only structure. By establishing transparent rules and custody standards, it accelerates the transition towards value-anchored money and on-chain settlement backed by tangible assets rather than debt expansion. Again, you guys, the US debt clock has been telling us that we need to eliminate the Fed, the fake fiat debt-based system. Once this is eliminated with the Clarity Act,
Remember what
is
we were
a
saying
huge,
earlier,
huge
Ann?
step forward. We're
Well,
seeing all
today's
the
Wednesday.
things happening
It only
with
comes
gold
out on
and
Wednesday.
especially silver, and the market is going crazy. Then it says, let the golden age begin. You guys have been keeping up with me the last 2 videos where I've been going over the sealed portion, which Daniel prophesied would be sealed up and brought forth during the end times, which is the Book of Mormon and this sealed portion that was just released recently, I think in like 2005 or something. But the information in this book is so vital, you guys. It is so vital. I'm going to go over this. Please stick with me. Now, my last video, we ended with the great blessings that will come to the Gentiles, okay? And building a city called the New Jerusalem. But to get to this, I have to explain to you where it says Eden, the Garden of Eden was in North America, okay? It says right here, Eden was in North America. And this whole page here, I put my notes, the land of Eden in America was prepared by God to be a place of refuge and freedom for those of Adam's future generations, and for only those who keep God's commandment. Now, this area is talking about when Adam left America or the land of Eden for Africa, okay? But it explains here, for the land of Eden shall be withheld from knowledge from the children of men until the time that I shall make it known again unto them. This is why America was not prophesied in the Bible, okay? And that's when America rises as the 8th beast when it was founded and becomes Mystery Babylon, which is going to fall again. Moving forward, it says, and I will make this land of Eden a promised land unto those whom I will. And I will cause that it shall be a place of refuge and freedom for those of thy posterity that honor me and keep my commandment. Explains right here. And if I did not save a promised land for this purpose, then the wicked of the earth would soon overcome the righteous, and the ends of the creation of the earth would be frustrated and complicated. For the wicked shall destroy the wicked, and unless I take the righteous from among them, they will destroy the righteous also. Now, like I talked about in my last video, you guys, the 8th beast was the Antichrist system, and it began when America was founded. We've already gone through the Antichrist system, you guys. Here it talks about all religions were deceived by Satan, every single one of them, you guys. That is the great deception, okay? We have been living in the Antichrist system. The USA was the seat of the beast. It has been. This is all the governments that has been in power since America was founded, okay? It explains here, and the beast is the governments that have been set up among you that ostensibly provide you with protection and the means whereby ye might have the blessings and the freedom and liberty and power to pursue the fine things of the world which the beast offereth unto you as a blessing for complying with its laws and order. The false prophet is all of the organized religions set up upon this earth that have been organized by the hand of man. It says several times in here that the Bible was changed. And we know that. We know that the Bible has been retranslated to mean different things, words taken out, things added in. Several times in this book, it talks about how the Bible was changed to deceive man. Right here it says, and that which hath been recorded in the Bible, which are the words of those people, hath been passed down from generation to generation since the laws were first given by Moses. And these laws were changed to fit the fancies and desires of men. This was all done to confuse people of the true timing of Christ's return. We have already gone through the Antichrist system. We have been living through the system of the beast. It talks about that they will give us a sign to know when the time is near, which it does talk about the Revelation 12 sign, but there is another sign that it talks about in here, you guys. And there's going to be a lot of people mad at me about this, especially those people who are spreading false information coming from the false prophets. They are the false prophets. So talking about the great blessings that will come forth to the Gentiles. It says, and great blessings that shall come forth to the Gentiles in the last days, even the coming forth of this entire record in its fullness, if it so be that they repent and receive these things. And the Lord spoke, saying, and verily I say unto you, this is Jesus talking, you guys, I give unto you a sign that ye may know the time when these things shall be about to take place. Even that I shall gather in from their long dispersion my people, O house of Israel, and shall establish again among them my Zion. Okay, we are to build the New Jerusalem. Once the Gentiles are lifted up out of captivity and receive inheritance into the promised land, you guys. It says lifted up, that is harpazo, that is the rapture, okay? Nevertheless, thou beholdest that the Gentiles who have gone forth out of captivity and have been lifted up by the power of God above all other nations upon the face of the land, which is choice above all other lands. This is the promised land, this is America, this is us, you guys, which is the land that the Lord God hath covenanted with thy father, that his seed should have for the land of their inheritance. Therefore thou seest that the Lord God will not suffer that the Gentiles will utterly destroy the mixture of the seed. Basically right here it's saying it doesn't matter if there's mixed seeds of the covenant people. Basically covenant lineages are preserved even when scattered or mixed. They still inherit the land. That's what it's saying. Now back to the sign, you guys. This is really important. Jesus is talking right here. It says, verily, verily, I say unto you, when these things shall be made known unto them of the Father, and shall come forth of the Father from them unto you, for it is wisdom in thy Father that they should be established in thy land and be set up as a free people by the power of the Father. And these things might come forth from them unto a remnant of your seed, that the covenant of thy Father may be fulfilled, which he hath covenanted with his people, O house of Israel. Pause and read right here. And when these things come to pass, that thy seed begin to know these things, it will be a sign unto them, that they may know that the work of the Father hath already commenced unto the fulfilling of the covenant, which hath made unto the people who are the house of Israel. And when that day shall come, it shall come to pass that the kings shall shut their mouth, for that which had not been told to them shall they see, and that which they had not heard shall they consider. For in that day, for my sake, shall the Father work a work, which shall be a great and marvelous work among them. And there shall be among them those who will not believe it, although a man shall declare it unto them. A man shall declare it unto them. Behold, the life of my servant shall be in my hand. This is the sign they're talking about, a sign. When these things are going to commence and come forth, this sign we will be given. Therefore, they shall not hurt him, although he shall be marred because of them. Yet I will heal him, for I will show unto them that my wisdom is greater than the cunning of the devil. It says, therefore it shall come to pass that whosoever will not believe in my word, who am Jesus Christ, which is the Father, shall cause him to bring forth unto the Gentiles, and shall give unto him power, that he shall bring them forth unto the Gentiles. And it shall be done even as Moses said, and they shall be cut off from among my people who are of the covenant. So this sign that Christ is giving us is saying that he has a servant doing his work who had an attempt on his life and was injured and was miraculously healed, and that this marvelous work will cause the kings to shut their mouth and consider what they had not considered before. I wonder who this person is. It's saying those who do not believe, even after it was declared to them to be a servant or a chosen one, all those who do not believe will be cut off from the covenant blessings.
Okay. Reading my Bible about all that stuff. That's the latest new one that just came out today. So the last two is going to be George. Oh, shoot. Oh, what I gotta do again? All right, this will be the first one. $15 on this one. It's okay. Thank you so much, Alton. Love you. See you tomorrow.
Unbelievably mistaken. We are never going to stop talking about this until consequences come, whether that's her getting kicked out of Congress or to the final step, denaturalization and deportation. We will never stop. We will keep our foot on that gas. We're going to burn that fossil fuel. Vroom, baby. Ilhan attended one of these protests in Minneapolis against ICE and didn't even realize, but she stabbed Tim Walz in the back. Tim Walz will probably be blowing up her phone right now like, Ilhan, man, why'd you do that? I'm already under pressure. You placed me under more pressure. Also, Ilhan Omar is now under a new investigation, a massive new investigation. And I know you guys hate the word investigation because it typically means no action, but you have to start an investigation before you get to that final consequence, right? Also, members of Congress are pushing for, subpoenas on her marriage, her husband and her, how she got all wealthy. So there's a lot going on with Ilhan. I want to show you guys this moment first because it really just tells you everything you need to know about this woman. She is mad that Trump is investigating fraud, saying he's wasting federal resources to investigate fraud. That's crazy.
I'm so exhausted in trying to ask what any of this, information has led to you finding any criminals that you have indicted that explains why you are wasting so much of our taxpayer resources and also terrorizing our communities in the amount of federal law enforcement agents that you have in the streets of our city and our state. There needs.
This lady thinks we pay taxes so Somalis can steal it. Like, she doesn't realize we pay taxes precisely so the federal government can conduct these sorts of investigations and prevent our money from being spent on fraud. Now, here is Ilhan at one of those protests, and I'm going to show you that moment that has Tim Walz really upset.
You all have refused to back down. You all have decided that this resistance is not one that can be intimidated. We are showing the nation that regardless of what the tyrant in the White House believes, we know that we are here to stay, and this is our country. We are going to make a life here, and we are going to stand up for our neighbors here in Minneapolis. As many
I can't listen to the whole thing. My brain's blowing up, man. I'm sorry. This woman, man, she's out here talking about this is, first of all, why are all these white liberals always around supporting this bull nonsense, man? Like, what are you guys doing? White people, lock in. It's your, like, okay, I know black liberals are bad, but they don't really like organize to protest ICE. They organize when they see an opportunity to loot stores and steal. But the white liberals just organize for the dumbest reason. But here's that big moment. Ilhan Omar, right, was in the middle of this protest. She was right there. And they started attacking Tim Walz in the middle of their speech.
Walls, grow some balls! Walls, grow some balls! El pueblo presente! El pueblo presente! He was taken by ICE just the other day. Somebody say shame! They murder when they ignore calls from people who really need them, and when they assist ICE. So to Jacob Fry, we say fuck you! You are not doing enough! Words are not enough! We need action now! Same goes to Tim Walz! You think it's gonna help anybody bringing the National Guard to Minnesota? No! Stop the war on the people!
So she's participating in a rally of people insulting Tim Walz and even the Democrat governor, which is bizarre to think about. But ladies and gentlemen, here is some major news, huge development. Journalist Chris Rufo broke on Fox News that investigators are looking into Ilhan Omar over her possible involvement with the Somali fraud scandal. She's only been seen in pictures with every single one of the fraudsters. Come on, guys. It's not possible anymore. It's, at this point, a confirmed fact.
Two good shows.
It's a constant of life. She is involved. She is of the fraud. But here's this breaking news.
I actually spent last week in Minneapolis, and there's two parallel stories. I mean, there is a panic within the Somali community. They've been found out for these massive fraud schemes, daycares, transportation, fake autism services, the whole 9 yards. But the political question is very important. And my sources in Minneapolis state government say that there are open inquiries into the potential involvement at the highest level of Minnesota politics. And so I think people will be taking a hard look, not only at Governor Tim Walz, but also Congresswoman Ilhan Omar and State Attorney General Keith Ellison. We know that they have connections with convicted fraudsters. The question is, were they merely complicit in these schemes, or were they part of a broader conspiracy? We don't have strong evidence now, but I think people are starting to take a look.
Well, what we do know is that Ellison promised these guys he'd make the investigation go away, and then he got money as a donation. We know that whistleblowers alerted the Walz administration and he didn't take any action. And we know a couple of these people, like Omar, got money from these convicted fraudsters as political donations. Are you saying that there could have been a conspiracy to move the welfare fraud money into their war chests?
It's certainly possible. And I think the person, and really I'm grateful for it, Scott Bessent, the Treasury Secretary, has all the tools at his disposal to actually investigate the money trail, to figure out how the money flowed between these fake nonprofits and Somali fraudsters and Minnesota politicians. And I'll tell you, the atmosphere in Minneapolis was electric. I mean, people had the sense of anticipation. Something big is coming. And look, I hope they get to the bottom of it, because we're talking about, some estimates upward of $9 billion stolen. These politicians seem to, at a minimum, have turned a blind eye to the fraud, or even directed people below them to take steps so that it wasn't uncovered. This scandal is not over, and I think it could end with significant action. And again, I think Secretary Bessent is the right man
for the job. Yes, that's huge, ladies and gentlemen. So, yeah, I don't think it's even a theory at this point that Ilhan was involved. I think it's a matter of fact. So here's what Nancy Mace is doing. She is calling for Ilhan Omar. She is a member of Congress, a colleague of Ilhan's, calling for her to be deported to Somalia. So I hope that materializes. But what I also thought was absolutely outrageous and unbelievable to hear was the mayor of Minneapolis, Jacob Frey, the complete fraud and idiot and buffoon running the city, saying the fraud is rampant. The fraud is actually rampant.
Save 50% off during National Reclining Month at Gardner White. Power recliners, sleek sectionals, personalized comfort. Only Gardner White has this huge a selection, all in stock today, so you can kick back tonight. And free same-day delivery. Save 50% only at Gardner White.
So, you think you know what pressure is? When 1 millimeter is the difference between life or not life, we call that a Tuesday.
Let me ask you about the leadership in your state. Dozens of people in Minnesota have been charged and convicted with stealing millions of dollars of taxpayer money for government programs. Do you think Governor Walz did enough to stop the fraud in your state? And do you support his decision not to run for re-election?
Well, look, Governor Walz is the reason that we've got paid family leave in Minnesota. He's the reason we've got free school lunches. Him and I, we've been through thick and thin.
But did he do enough to combat fraud,
over these
Mayor? Did he do enough to combat fraud?
Look, obviously, everybody could have done more to prevent fraud. And I think that's a fair point to make. Do more to prevent fraud. And you look what he's doing right now. He's setting up a whole bunch of infrastructure to do that. And by the way, look, the fraud's real. We've all got to acknowledge it. The fraud is very real. And by the way, when somebody commits fraud, and there are many that have done that, you investigate it. You charge, you prosecute, and you put the person in jail. As an individual, you put the person in jail as an individual. You do not hold an entire community, any community, accountable for the action.
Yeah, but if you put all the people who are involved in the fraud in jail, you're going to end up putting the whole community in jail because the entire community is involved. So here's what's interesting. Dustin Grage, who is a reporter on the ground in Minnesota, reports that Ben Davis, a representative in the Minnesota State House, tells him that articles of impeachment have officially been drafted. Accountability is coming. Now, at the very least, Tim Walz will get charged by the Minnesota House, but he will certainly get cleared of all charges by the state Senate because it's run by Democrats, but the state House is run by Republicans. So Tim Walz is in big trouble, reputationally speaking. An impeached governor, it doesn't matter if he's convicted, is still a very bad look for him. So that's huge, ladies and gentlemen. Like, that's accountability. Is that not what we've been calling for? We've been asking for these politicians on the right wing to do something. Like, punish somebody. I don't care if it's not going to go all the way through. I'd like to see some action. I don't just want to see endless investigations because we know enough. We know that Keith Ellison was in some quid quo pro, which is what they accuse Trump of, right? Projectocrats, they project upon you what they are. We know that Keith Ellison, the attorney general, was involved. He had communications with these fraudsters. Hey, if you support me, I'll make sure you don't end up in handcuffs, in jail, in prison. We know that Ilhan Omar has taken pictures with countless fraudsters. Does that not imply deep levels of guilt? And I don't really believe in guilt by association, but in this instance, like, I have to believe it because it's a community thing. So I think we're going to see some major, absolutely major development coming out of Minnesota in the next few weeks. I don't think this thing is going away. This is too much money on the line. We're talking about billions of dollars in stolen funds. I combine money with funds. Muns. That's genius. We just invented a new word. I know you guys in the comments are going to be like, George, why don't you learn to pronounce everything first? You guys make fun of my pronunciations. You don't see me around here committing fraud. I'm not a Somali. What do you care for? See, you're going to say care. Like, look, my tongue is too masculine. Like, Chocolate Superman doesn't need pronunciation advice. If I want to say clearly, I will. Clearly, George. Okay, whatever. Not you know what you guys are doing now. You're saying, George, you're saying America wrong. Okay, what am I saying wrong? You're saying amendment. It's actually amendment. Okay, guys, come on. What are we doing? Anyways, justice and accountability is necessary. President Trump told the New York Times that he is open to denaturalization for Somalis, and I think that's great. I think the president should absolutely pursue that. There was also reports that he's dissatisfied with Pam Bondi, and I think he also publicly said something about not seeing enough from her. And I think it's the frustration that he sees all what we're seeing, but he's not seeing aggressive action to stop it. So I hope the president is pushing Pam Bondi to do something. You know, Tim Walz has been referred for criminal prosecution. Ilhan Omar should be next. They should find something on her. Look, I don't believe in fishing expeditions to get your political opponents, but I do believe in fishing expeditions to get Ilhan Omar because there has to be consequence for what she is. She is a fraud. Everything about her is fraudulent. She married her brother to give him benefits, to green card status, and many other things. She has to be held accountable one way or another. And if you don't do it, you're going to have anarcho justice. And we don't want to see that. We don't want to see vigilante justice. We want to see true justice from the state, which we pay for. Thank you all very much for watching. God bless and goodbye.
Okay, so wrap it up for tonight. We got 2 good shows today. A lot of intel going out. But tomorrow I'll probably go to 6, back to 6. 2 shows is hard. So much work, intel out there. But anything big, I'll come on. If anything big happens. Thanks, Kay, Lucy, Tim, and then JJ and everybody. God bless everybody. Remember, please hit like and make sure you go to the description box and sub to the backup channels. And stay safe, stay strong, keep the faith, and never give up. Till tomorrow, another night. Intel. Signing off, Chico and Dude.